Well, with the consent of the petitioner, my lord, I need accommodation for today only, my lord.
Which one?
Item number 9. Here the governor is dependent by the senior counsel D. Saika. He's out of station.
Item number 9.
9, my lord. My
Why?
first is appearing for the petitioner.
What is this matter about?
Matter regarding the governor calling for swearing in, he is telling the calling for swearing at the PTC council.
Who is appearing for other side?
My lord, I am for the petitioner, my lord. My lord, my senior friend has expressed some difficulties today, my lord. The date may be fixed, my lord, in this
Any day,
week,
my lord.
last part of the week, my lord.
We'll have it on. Last part of the month.
My lord, week, my lord.
Week. Today is Monday, Tuesday. You want it on 3rd?
My
Not
today,
possible.
today is, my lord, first,
We'll have it on 8th.
my lord.
Lordship.
At the request of the learned counsel for the respondent, matter stands adjourned till 8th of August.
All right. This matter may be posted for withdrawal tomorrow. Pertaining to bench 5.
This is bench 5.
My
You mentioned it before. This is Shumon Syam. He's the senior bench.
Please, Your Lordship. I wish to mention for listening of a petition for Friday.
As I told him, you do the same. Mention it before Justice Syam.
Lordship, I beg to mention item number 3, Lordship.
Item number?
3. For part over.
Oh,
Lordship,
no.
Lordship, Mr. B. Sinha is not well. He is not here. He is suffering from high BP. Lordship.
You do it.
Lordship, I am not.
2011 matters are not for adjournment. Next. No 2011
Not
matters.
here since Friday.
No, sorry. You do it.
I like to mention that for listing. The matter
Huh?
is absent. Mention for listing.
Mention it before court number 5. Go. Yes.
Item number 1.
Current line.
Wait, please, your lordship. My lord, in this matter, may I just request for a small accommodation. After some time, certain clarifications were sought by the honorable court of the last occasion. And an affidavit is being filed today on behalf of the respondent number 227. It is just in the process of being brought to the court, the honorable court, subject to your lordship permission. If your lordship takes up the matter after some time.
Okay, we'll take it after some time. Yes, what is the matter? Let us see first.
Yeah.
What is the matter about?
The writ petitioner,
If you can take for
which
Yeah.
is a farm owned by the individual, the farm.
Mhm.
It has, on the basis of a contract order, work order issued by the IWAI, my lord, constructed and repaired certain pontoons, my lord. And the agreement provided that it has to be delivered to them after doing the work after 7 months. There was some delay. They have given extension also. Even after that, there was some delay. So after we delivered, we raised our bill. Bills were paid, but the liquidated damages for delay was deducted from our bills. Then we filed an application for waiver of the LD because the agreement particularly in clause 14 provides that if the engineering charge certifies that delay was beyond the control of the petitioner, then it can be waived. Accordingly, we made an application. He inspected, he made his.
But Mr. Mazumdar, how does this court decide whether it is beyond the control of the petitioner?
No, I'm not on that. I don't want this one to decide.
Yes.
The engineering charge is decided. After that, they are not honoring. They are saying that it has to be, the decision has to be taken by the higher authority. When the agreement provides that it is to be certified by the engineering charge. Engineering charge is
Let us see
specifically,
that clause.
my lord. Clause 14, my lord.
Clause. Page.
Page
32. Page to deliver the cocoon within the period fixed for such delivery by all.
Page 32. If the contractor fails to deliver the pontoon within the period fixed for such delivery or at any time repudiates the contract before the expiry of such period, the owner may, without prejudice to his right, recover damages for breach of contract damages equivalent to so and so. This we can skip in the middle, my lord. There are two capital letter words, provided always that if the engineering charge shall certify in writing that such delay or any portion thereof has arisen either in connection with the works of the contractor or their authorized subcontractor due to force majeure or other cause which in the opinion of the engineering charge on behalf of the authority were unavoidable and could not be foreseen or overcome by the contractor, then and in such cases the liquidated damages shall not be payable in respect of the period certified to be due to such cause, and the engineering charge on behalf of the authority shall have power to extend accordingly the time fixed for completion. Then next paragraph is important manner. The term force majeure shall herein means riots, etc., civil commotion, war, invasion, act of foreign enemies, hostilities, civil war, rebellion, revolution, insurrection, military, etc., etc. Then my lord, line number 2 from the bottom, and other such causes over which the contractor has no control and are accepted as such by the engineering charge, whose decision shall be final and binding.
So you say that the engineer in charge has certified,
Yes, my lord, I have
so no liquidated damages should be imposed
Yes.
upon you.
according to him, the delay was for reasons beyond my control. Even after that, they have not honored this. They say that it has to be taken by the higher authority, but the agreement specifically provides the engineering charge is the authority.
And Mr. Mazumdar, why should we exercise this writ jurisdiction in this matter? Why didn't you go to the civil court?
No, my lord, civil court,
No, why? Are these matters to be taken up in a writ jurisdiction?
my lord,
Why should this
my
court
lord,
decide?
IWP is an authority under Article 12.
So what?
My lord, here it's a case of arbitrary exercise of
Then
power in not,
if it is an arbitrary exercise of whatever, maybe it is a question of, they are saying that no, it has to be liquidated damages. Where is the entire agreement? Why haven't you enclosed the entire agreement? Yes, Mr. Doctor, what is your stand?
Whether our standard prima facie twofold. Twofold step. First of all, there is an arbitration clause in the agreement, and which provides an effective mechanism of dealing with the grievance that the petitioner is seeking to raise. He has not resorted to that and straightway rushed to the writ court. This is number one. And also because of the fact that the conduct of the writ petitioner as is available on record, the contract itself was procured by submitting forced bank guarantees. That has come on record. Now, in such a circumstance, whether your lordships will be
No, Mr. Doctor, those are,
no, that is
the second one doesn't appeal to this.
that
The
is-
reason
that is-
why it is does
that is
not
a
because you have
posterior-
got the works done.
Yes.
And then you did not realize all this while. Now you are saying that the initiation of the contract itself was wrong because he has submitted false documents. You
Even-
terminate it.
Even if I leave that submission, Lord, the first thing is that there is an arbitration clause, and as your lordship has said that this arises at
Where is the
dispute-
arbitration clause?
that is clause 21. That's why, my lord, we were trying to file the affidavit. I can give
My
the
lord, arbitration clause.
No.
that is clause 21 of the bid document.
Well, arbitration clause will not come into play for a simple reason, my lord.
These are not cases, Mr. Muzumdar, for invoking
No, my
the.
lord, it will not, it's not arbitrable, my lord. Direct, I can show from the arbitration clause.
It is permissible or not, why you are not invoking the arbitration
No,
clause
my
or
lord-
whatever clause?
My lord,
Why, if arbitration is not there, go to the civil court.
Lordship, may kindly have a look at the arbitration clause itself, very first paragraph, Lordship got my lord, 21.1.
Except as otherwise provided. herein
Except as
before,
otherwise
all
provided herein
questions,
above.
disputes or
All
difference
questions,
in
disputes
respect
or
of which
difference
decision have
in
not been
respect
made
of which the
final and
decision has not been
binding.
final and conclusive arising between the contractor and the authority in relation to or in connection with the contract shall be referred for arbitration. Now the clause 14 itself says it is final. Clause 14 is very clear, my lord. It says the decision of the EIC engineering chart is final. That means the position, nothing remains to be decided by the arbitrator, my lord. And it is not arbitrable. Clause is very clear, my lord. Article 14 says the decision of the EIC shall be final. Now, arbitration clause says only in respect of disputes arising out of a decision where the decision is not final will be referred to the arbitration. Even otherwise, when lordship is aware, my lord, arbitration clause by itself will not be create a bar, absolute bar on the exercise of jurisdiction by your lordship. More so in a case where there is no disputed question of fact.
No, why should this court at all decide?
I don't. This court can,
Merely because it is not a disputed question of fact, you have a remedy out there. Why you are not taking that remedy and coming out here?
my lord,
Forget about the arbitration clause.
my lord,
Why you are not filing a civil suit if there is any, there is a recovery to that effect?
my lord, this is a case where nothing is to be decided by the civil court. There is no question of fact. I should not lead in, I need not lead any evidence to prove any fact. The documents are so clear, my lord. It is staring at the face that the contract specifically provides that if the EIC, engineering chart, certifies that the delay was for reasons beyond my control, that is the end of the matter. Now that has been done. Beyond that, what is to be decided by the civil court? What is to be decided by the arbitrator, my lord? Lordship, may kindly have a look at this clause once again, my lord. 14 is very, very clear. Power has been given by the parties have decided to confer the power on the engineering chart.
Where is the arbitration clause?
My lord, clause,
Clause 21,
Where?
my lord,
well, I'll just hand over
I'll just find it out.
No, in which section?
21.1.
That will
Which
be in the
section? There are
page
many.
Oh, yes.
67.
My lord, possibly.
Page 67, it will be page 67 in that compilation. Page 67 on the below, page markings are down in the, down below in the page.
It is GCC, my lord, general conditions of contract. Part 1. Part 1, section 2, Roman 4. my lord. Internal law.
My lord, may hand it over to me, I will find it out.
Well, may I hand over my copy?
Yes, Mr. Doctor, why 14 is not applicable?
14, according to us, my lord, the 14, the opinion of the chief engineer in chief, that has to be in consonance with the opinion of the competent authority. That is the employer of the contract, which is the chairman of the IWAI.
Where is it?
Now, your lordship will kindly come to page 32.
Huh?
Page 32 of the writ petition.
Yes.
From
Tell me.
page 32, clause 14, about nine lines. Provided always that.
If the
Provided
engineer,
always that if the engineer in charge shall certify in writing that such delay or any portion thereof has arisen either in connection with the works of the contractor or their authorized subcontractor due to force majeure, or the cause which in the opinion of the chief engineer on behalf of the authority. Your lordship may kindly mark this expression. The opinion of the chief engineer has to be on behalf of the
chief
authority.
engineer, no, engineer.
Sorry,
in charge.
engineer in chief.
On
Engineer in
behalf
chief,
of the authority.
that has to be on
Are
behalf-
you saying that the engineer in charge was not acting on behalf of the authority?
My lord, our contention is that engineering in charge, the opinion of the engineering in charge has to be in consonance with the final approval of the.
No, that
Authority.
can't be there. But the engineer, are you saying that the engineer in charge went beyond the scope of his authority, or he did not consult the authority concerned?
Here in the.
But here it says that engineer in charge on behalf of the authority, meaning thereby that he will act on behalf of the authority.
He will act on behalf of
What
the
actions
authority.
have been taken upon the engineer in charge thereupon? When he has given that particular notice, given him a clean sheet,
No.
what
The
actions have been taken?
The engineer authority, engineer in chief will have to be guided by the final approval of the authority.
Where is it?
Well, the authority is in the bid documents, my lord, the authority is the IWAI. Engineer in chief is merely a.
But where is it mentioned that he has to do it from the engineer in charge?
My lord, if you-
Engineer has to take the authority from so and so.
well, that is the defense put forth. I'm saying that is the defense put forth in the affidavit.
Defense.
Now,
Give
otherwise,
me a reasonable defense.
also, my lord, the kind of recommendation or the certification which the petitioner is seeking to project, that is merely in the form of an interdepartmental communication. Nothing has been communicated to him. It was only because at the time when the LD was charged, he made certain appeal before the authority in the department, that is the chairman IWAI, and the certain comments were called upon from the engineer in charge. And during the course of communications between the two officers of the department, something have transpired, which the petitioner wants to project as to be the final
So
recommendation.
there is
of the
no
engineer.
certification.
No, there is no
So
certificate.
that becomes a good ground.
There is no certificate.
And did he, you see, kindly come to the next page.
The decision shall be final.
No. Decision beyond that. In the event of
Of
either
either-
party being rendered unable by the force measure
To perform any
to
obligation.
perform any
required to perform
obligations required to be performed by them under this contract,
The relative.
the
obligation
relative obligations required to be performed by them under this contract, the
And-
relative obligations of the party affected by such measure cause last.
Yes.
Provided the party alleging that it has been rendered unable as aforesaid,
Thereby
thereby shall notify within 15 days of the alleged beginning and the ending thereof, giving full particulars and satisfactory evidence in support of such cause.
Yes.
Is it there?
No, they only said that because of ABCD circumstances, our hull was not inspected, the weather was inclement, we could not do it in time. Now, there were correspondences between the parties. In the process, certain amount of extension was granted to them in the first event. Now, even thereafter, they could not complete it within the extended period of time. So therefore, after considering the all over aspects of the matter, the final decision was taken that it will not be a case of grant of full LD. That
Where
is-
have you stated in your affidavit that it was never, it was that these are interdepartmental, which was never
that
certified?
is the affidavit, my lord, I indicated in the beginning. That is the affidavit which is being.
Oh, you have not filed an affidavit
No,
without taking that stand?
It has been filed, my lord. It is just in the process of being brought to the.
No, this writ petition was filed in the year 2014. That is not your defense in your affidavit, which was filed in the year 2014. Now, is it something an afterthought?
No, my lord.
Yeah.
In the affidavit that was filed initially, my lord, the things were not properly clarified. That's why, my lord, this is a supplementary affidavit which we have been filing today.
Where is the certification on the basis of which the petitioner is claiming?
My
That
lord,
is page
start from page-
37.
My lord, lordship may kindly speak from page 36 onwards,
Page?
36 of the report.
Ah.
Number
Yeah.
there, sir. After the, just after the table, Director IWAI Guwahati was the EIC of the above work. Final bills of all three contracts have been released, and 10% of the total value of each of the contracts was deducted as compensation for delay in the form of LD as per clause 14 of the special conditions of contract. Mr. Swenso, the petitioner, my lord, had requested for release of the amount deducted against LD by letter number Swenso dated 7/4/11. The firm was requested by our letter dated Swenso to provide adequate documentary proof to substantiate delay and establish that the same was beyond their control. The firm has submitted some documents and details by letter cited above, which are enclosed herewith in original. It is requested that the documents may please be examined and recommendations of the EIC as per the contract clause 14 of the special conditions of contract
Then?
may be. Then next page, madam. Then director writes to the deputy director IWA Noida. In reference to the above, it is to bring to your kind notice that this office has examined the documents submitted by Swenso for waiver of LD in regard to the contract were awarded to the agency for construction supply of floating steel pontoon in Swenso on various reasons beyond their control. After examining the documents submitted by the agency, Guwahati office has calculated the delays which have occurred during the construction of the floating steel pontoons due to reasons beyond the control of the contractor. In this regard, it is to mention that severe delays have occurred due to delay of IRS inspection of the pontoons at different stages of construction. A summary of the calculations enclosed were herewith for your kind perusal. The detailed calculation of the delays attributed due to late.
And this
inspection of-
director is the engineer in charge.
Yes, madam.
He's the
No.
engineer in charge.
Yes, madam.
He was the engineer in charge.
Next page, Dr. May kindly see now. 25/4/2013. Assistant Director from Noida writes to Guwahati Director. Please refer to this office letter to this Swenso cited above, by which it was requested to furnish definite recommendation on the delay caused on account of inspection by IRS, launching of pontoon and supply of anchors, etc. to consider waive out of LD deducted. The reply is still awaited. I am directed to request you to submit the same at the earlier. Now the next page, madam. With reference to the above, it is to mention that detail as furnished by Mr. Swenso has been examined by this office, and a summarized statement on the delay caused on account of inspection of IRS, launching of the pontoons and supply banquet, etc. has been forwarded with due recommendations by our above referred letter dated Swenso. Further, as per the contract agreement for all three projects, the Director IWAI Guwahati as EIC is recommending the waiver of LD based on the statement submitted by the contractor for reasons stated to be beyond the control of the contract. Now, next page, some details have been given next 2 pages.
Now, why is the engineer in charge recommending?
In fact,
He was supposed to certify.
certify. That-
By why is he recommending? Is he not then asking the authorities to take a decision? And he is not taking a decision.
The language used by him has to be seen in the context of clause 14. His power will be limited to clause 14, nothing more, nothing less than that. Clause 14 says he is the authority to certify. In whatever language he has done, but then he is recommending that reasons were beyond my control, so why the delay is concerned. And
So that means the engineer in charge
he is certifying.
is not certifying. He's only recommending that you kindly waive this liquidated damage.
My
And
lord, he
not
also
only that,
says-
my lord,
my lord, he also says that about the reasons for the delay. He says that,
No, I've seen the reasons which have been given out
My-
there, page 41.
my lord,
your lordship
that
may also put
what
some.
what language he has used is, in my humble submission, my lord, will be not so relevant. What will be relevant is what is his power under clause 14. Clause 14, whatever he is saying in favor of the petitioner, that there was a delay and it was beyond his control. Now it's for the authority to act upon his letter. The word used like recommending, etc., may have to be.
But Mr. Mozunda, don't you think it is the other way around? Here is a case where the liquidated damage has already been imposed upon you.
Yes.
And then these authority who have done it, they have asked the engineer in charge to give a recommendation, or what is your statement as regards for which he has said, yes, I recommend that there should be a waiver of all these things. That is being done.
Right.
On the other hand, if you see section, this clause
Clause
14, it stipulates that 10% at the maximum you can impose a liquidated damages, but then also on account of delay. But if there is a delay and the engineer in charge satisfies it, the authority should not impose the
My
liquidated.
lord is absolutely correct. Well, I also go by that. In fact, what procedure they should have adopted is, before finally taking a decision on my bills, they should have settled this matter. The engineering charge should have been should have been approached for to say what about his opinion.
No,
Can
that
you
would have
satisfy?
been dependent again when you are approaching the engineer in charge and telling him that look here, 15 days before and 15 days after that,
Yes.
look here, this I have done it. And then the engineer in charge comes up with these and says that yes, this has happened because of unforeseen circumstances.
My lord, your lord is absolutely correct. What I'm saying is, my lord, this should have been the procedure. But here possibly a different procedure has been adopted because of their letter. It's the page 36 or to me kindly see. Kindly see. This will show why this procedure was adopted. This is the letter 4/8/2011 by which they have actually honored my bill, and then they say it is requested that documents may please be examined and recommendations of the EIC as per the contract. They have already deducted. Final bills of all the three contracts have been released and 10% of the total value of each of the contract has been deducted. They themselves have deducted first, and then they said you kindly now do the exercise of waiver of bill. So they have, my lord,
But wouldn't that require, you see, the engineer in charge has to first take a call.
Yes.
On being approached by you,
Right.
saying that these are the circumstances on which it has happened.
Right.
And when he certifies and says that yes, this is within time and as such should be removed, then in that circumstance, which would be final, the authorities cannot impose liquidated damage. This is
I-
the circumstance.
absolutely.
But
Yes.
here what has happened, the liquidated damage has been imposed and
Then-
then after this question has arisen.
I agree to that.
Now that 15 days, whether you have done or not, wouldn't that be a subject matter of adjudication of facts?
I don't know. My submission will be ultimately what will be having the bearing on the question as to whether I'm entitled to recovery now, although the thing should have been just reversed.
I'm not
It's
on the
not
question.
payable.
No, I won't, I am not saying that the engineer in charge has to take the approval of the authority which he submits. No, I'm not on that.
Right.
But the question is, you can't, the power as per section 14 is, or clause 14 is, you can't impose liquidated damages if there is a certification by the engineer in charge that this is the amount which has, there is a, that these happen due to unforeseen events.
Right.
And for that, you need to move the engineer in charge at that relevant point of time, 15 days prior to this one,
15 days.
that this is happened, and as such, he will give a certification, this has happened. Now, what has happened is here, initially, they have already imposed the liquidated damage. Thereupon, they are calling for the report from the engineer in charge. Engineer in charge come up and says this. But would it be proper on the part of the engineer in charge if there is no documents of you informing the engineer in charge that look here, this is the circumstances which have happened?
Well, my
And therefore,
my-
my lord, the engineer in charge also says that it is stated to be the reasons for delay. It does not contain his independent finding or independent opinion that this is the reasons I have considered, and in my opinion, they should be waived off. That is also not there.
in fact, my lord, if your lordship goes to page 36 once again, the second paragraph from the bottom says that this letter is of 4th of August, 7th of April itself I have written that the farm was requested by our letter dated 24th April to provide adequate documentary proof of substantial.
No, this is on 7th of April, you ask upon deduction of the or retaining of
Yes.
the 10%.
Right.
And as such, you sought for release.
Right.
And this is the consequence which has happened is the letter by which 4/8.
Right.
But the fact as to whether you inform the engineer in charge at that relevant point of time,
Right.
that this is the reasons which has happened.
That's what was 14.
That is the only thing.
There will be a procedural part in my humble submission. Ultimately, what will transpire is that whether there the engineering charge certifies or not. Engineering charge has.
That is why engineer in charge is recommending. he can, normally in contract, what happened, the engineer in charge gives a certification to that effect that look here, these periods should be excluded, taking into account that he has informed this is being done.
That's correct.
There are in many cases where you see that an extension is being granted without prejudice and with prejudice.
Yes.
So this must have happened. All these things will require examination. How can it be done? That is why the engineer in charge is not recommending. It is a pursuant action which has happened pursuant to this, you filing on 7/4 and they writing, and then the engineer in charge says that, look here, these are the things I am satisfied. But whether you have informed them prior to that, whether you come within the ambit of that, these are questions of facts.
Your lordship is saying, but then it is not their stand. Their stand is very simple. What they are saying is, no, although engineering charge is the authority, but there is a higher competent authority which will take a decision. Here, my lord, my submission will be, this will be an improvement over the agreement already signed by both the parties. Agreement specifically provides that the whole entire authority has been given to the engineering charge.
Understood, but that is subject to you informing him within these 15 days.
That is why I said, my lord, please, they have not taken, my lord.
They have not taken, but when I have to take it, I have to take it.
They are pleased that there is a competent authority will decide. They are
Help it,
trying
Mr.
to avoid
Mujumdar.
the terms of the contract.
I am not thinking on this. I am only thinking how to save your limitation for filing a
My lord,
suit.
even if arbitration at this stage, there is a question of limitation.
Huh?
Yes.
Can I bring in section 12? That is the only thing I am worrying. I am not on the other thing. This is already satisfied. What to do with section 12? How do you save the limitation for approaching? Mr. Mazumdar,
My
how do you save your limitation?
my lord, if now I have to go for arbitration, a question of limitation will come.
Huh?
If now I have to go for arbitration, question of limitation will definitely come.
How do you do it? Because this court can't look into that 15, whether you have done it on within 15 days. If we are to go on that, but would you say, there's no doubt, the engineer in charge certification would be final. There's no quarrel with that. But whether you disputing the imposition of liquidated damage would be final.
I
Cause of
couldn't follow you.
whether you disputing upon your dispute being done to the imposition of liquidated damage by them of 10%, is it final in view of the litigation?
My lord,
The certification may be final as per you,
Fine.
which that plea you can very well take it. But would the imposition of liquidated damage would be final if this action is already been taken?
my lord, by the letter by which they are saying that they have deducted, by the same letter when they say,
No, when you are asking them for return,
I have asked, of course, there is a letter, my lord,
you asked on 7/4
7.
for returning it. And then these recommendations comes in and thereafter they don't do it. Would it become final when you have disputed this action?
My lord, if your lordship goes to that paragraph again, 7/4 I have asked. But
Huh?
soon thereafter, on 25th April, they have requested me to provide adequate documentary proof to substantiate delay and establish that the same was beyond their control.
So it has not become final. As regards liquidated damage, you may take the help of the recommendation.
Recommendation is final.
You will take the help. That recommendation becomes final or whatever, may be. Whether it is final or not, that is another aspect of the matter. But can you now, on the basis of that, Can you take the benefit of section 12 or 14? 12 or 14 of the limitation, 12 of the Limitation Act? For the purpose of arbitration? We'll take it up at 2.
My lord,
2.
one matter in court number.
Ask your junior to be there.
Or
Or 3 o'clock.
3 o'clock,
You are saying in which court?
court number 1.
Court number 1, would you sit till 2 o'clock? Unless there is a special bench.
And it is mentioned in the causing itself.
Okay, then it is 2, then 2:30 will be over.
Mile,
So
3
then
o'clock.
That's good.
You just find out how you can tackle that. I'm only worried about that.
I don't know, 2.
Yes, Mr. Nair. What is this matter
Isha,
about?
with my lord, is the wife of one Gautam Thapa who had initially instituted this writ petition. He was an employee of the Assam Rifles. Initially as a rifleman, thereafter they remastered him as a clerk and then promoted as a Havildar. Then, my lord, he applied for voluntary retirement. That voluntary retirement was granted on 11/8/2000 with effect from 31/3/2001. That, my lord,
11?
would find at page 12.
Yes.
My lord, this was done. And the subsequent
Provided
order-
no disciplinary case is pending.
there was no disciplinary case pending on that day. My lord.
Okay.
Then, my lord, on page 14. My lord, this is the reduction in this strength of the force. So and so strength decrease voluntary retirement. So and so Havildar clerk, Gautam Thapa will be retired from service on voluntary retirement with effect from 31/3/2001. So and so names and all given. Now what had happened, my lord? He had proceeded on leave. Casual leave. And then he stayed back. He was suffering from viral hepatitis with alcoholic psychosis.
Wait. You have been given voluntary retirement from when?
My lord, my voluntary retirement was to come into effect
31/3/2001.
from 31/3/2001.
And then?
Then, my lord, he proceeded on leave.
On-
And during it was from November onwards, he proceeded on leave for around 12 days. He had to, my lord, thereafter remain under treatment that my lord would find at page 15.
For 5 days.
7/12 to 12/12 viral hepatitis. Then he was under his treatment for alcoholic psychosis till February 2001.
Okay, then
Thereafter, my lord, he came back and he joined on 24/3/2001.
22/3.
24/3.
Okay.
He joined, he was allowed to join. But my lord, he was not allowed to proceed on voluntary retirement with 31/3. Subsequently, they instituted a proceeding. They held a court martial. And in that court martial, the order is at page 17. The so and so enrolled in Assam Rifle. The individual has 20 years, 8 months, 24 days service as well, so and so. Individual was granted 25 days EL with effect from 16/10/2000 to 12/11/2000 and failed to report back on due date and remained absent without leave and intimation till individual reported back voluntarily to this headquarter on so and so.
Hmm.
Total absence 132. The individual is habitual offender as he has overstayed leave on 3 occasions in the past for which he was punished to amend his attitude, but he again overstayed leave for 132 days without any info to authority. The HQ is deployed in intense counterinsurgency environment where such unsoldierly contact of the OR is highly detrimental to maintenance of moral discipline of so and so. Hence, award of stringent punishment in such cases is a must. Therefore, keeping his past record and gravity of the offense and its overall impact on operational efficiency, discipline, and moral has been tried by summary court martial and is been sentenced to be reduced to rifleman and dismissed from service. He then, my lord, submitted a petition. Then he said that because you have been now set aside, sent out, dismissed, you will not be entitled to pension. In the affidavit that has been filed, my lord,
Now, what are you alleging? Challenging?
I am challenging this order, my lord, 17.
Why?
Because, my lord, I was under I was given voluntary time. During that period, there was nothing. Subsequently, you took up this proceeding.
No, you see the language out there, paragraph 2 of page 12.
My lord, this is that four-red entry. Four-red-
Voluntary retirement in respect of following of your unit is hereby approved
Approved.
with effect from the date shown against each in terms with the MH letter, provided no disciplinary case is pending against him, them.
On that day, my lord, there was no disciplinary case. There was no disciplinary case. My lord, the records are here, my lord.
Hmm.
My lord can see, there is no disciplinary case on that paper. Disciplinary case came after I joined, after 31 3 months. They did not allow me to.
Now, what happens is, just for example, a person who have been given a voluntary retirement in this state,
Lord.
and thereupon he does something very wrong or gross misconduct, nothing can be done.
My lord, it should be done.
Then?
But my lord will also, in such a circumstances, my lord will also, they will have to also weigh the gravity of that offense. What had happened here, the man had come back, he had given the medical certificate.
So you are not on page 12 then.
Page 12, my lord, what I am saying is, page 12, 31/3/2001, you retired me. You gave me voluntary time. But my lord, that could not come into effect because of this. Now this has come, my whole service has been wiped out. The man is no longer there. Admittedly, he was an alcoholic. He had issues, my lord. He was under treatment. The record will show that he had given medical certificates for that. But these were never taken into account. He was a clerk. He was not a competent. Although he is in a competized post, he was not a competent. He was a clerk in the office. So those words that the operational efficiency is being reduced, while saying that they also ought to have taken into consideration his condition. He was not fit to work at that point of time. And there is a certificate, and that, my lord, that certificate is reflected in the records also. Last time my friend had produced, I had put 2 green flags there, my lord. My lord would see. Last time what it transpired in the court was, my lord, the dismissal is not creating problems for me. The family, my lord, is in penury. Nothing, my lord. Nothing they are getting. So even if, my lord, that penalty is reduced and he is entitled because he has that qualifying service, my lord, 20 years, that family pension, at least, my lord, the family would be entitled. Because this is a finding without considering his condition.
That person has died.
Died. The person has died, and that
When?
was subsequent. He died in, my lord, 2011, my lord. 2/10/2011. Just after filing of the petition. It was filed in February, he died in October. Very bad condition. Somehow he came up before this honorable court and this case could be filed. Then thereafter the wife came and she was substituted.
So what is the effect of the relief you are asking then?
My relief is, my lord, that this order at page 17 is to be interfered with. My lord, as an officer of the court, if my lord is, my prayer would be that the whole thing, reduction plus dismissal, has to be interfered, because the other aspect as to why he was, because my lord, I was staying unauthorizedly absent, whether it was without any cost. If it was without any cost, then it would have been an effect, my lord. I just was, my lord, abandoning my work. But if there is a cost, they'll have to take that into account, which was admittedly not taken into account.
So you are on, therefore, on proportion.
Proportional. They'll have to, my lord, this has to go, because
So
proportional,
not on page 12.
not page 12. Page 12 is now done with. Because I'll continue till 2/6/21, my lord, 2001. Because if I pray for page 12, then, my lord, we will be required to put the clock back, which may not be, my lord, proper, because something has happened thereafter. So that has to be taken out. This has to go. Because
And if I put to page 12, it will have far-reaching consequences in other matters also.
Matters
What
also.
will happen in the meantime, if something very
my lord,
serious?
that I may not be in a position to pray. I'm
No,
only
what is
showing
your-
page 12.
No, what is the effect of your relief now?
Effect of the relief would be, my lord, he will be paid his pensions.
From,
From, my lord, 2/6/2001, 2/6/2001. Whatever pension he is due, then thereafter, my lord, from 2/10/2011 afterwards.
so
family
then
pension.
in that regard,
Lordship.
when can a pension be withheld if it is a dismissal?
My lord, if it is a dismissal or a removal, pension is automatically wiped off. Compulsory retirement, I get it with pension. If it is a dismissal or removal under CCS rules, I don't get, my lord. It's gone. Pension is gone.
So we have to therefore see on the basis of the materials on record, what is the,
Lordship.
can it be a case of proportional
Lordship.
punishment?
Because, my lord, if my lord finds that the stand that he had taken in any manner, because they had held a summary proceeding, with any manner he had taken a stand, whether, my lord, they had gone into that, found that that is false, it would give you a different impetus. Because here there is nothing, my lord, in the order.
But you have not enclosed anything.
My lord, this is the maximum which the man could give, my lord. Only the certificate is there at page 15, which my lord will find corresponding in the record also.
This is only a certificate issued by.
The, my lord, Coal India Limited Hospital, which is there in on record. They have taken it as an exhibit. There were other two prescriptions also, which I don't have, but it's there in the records. Not the document, but the description of that.
Now, whether this certificate was given to the.
Yes,
authority,
yes.
I mean,
The certificate was not there, Lordship.
No, no,
It was mentioned, Lordship. No, certificate, they mentioned, the certificate was not there, he was mentioned. there.
Exhibit. I'll just point.
now, did you consider his health?
Yes, yes.
Yes, it has considered, Lordship.
The
Because
certificate is there.
certificate is, the date was mentioned there, Lordship.
That
but-
is an exhibit there. But the
Exhibit
copy
there,
is not there, but it's an exhibit in the. Because last time my friend was kind enough to give me the record. So
this is the statement, Lordship.
So there was a departmental proceeding.
that's one
Yes.
of the, my lord, witnesses which has been examined.
What is this apprehension rule?
Apprehension role means, my lord, I think that's the convening.
If he doesn't appear, Lordship, with notice, then apprehension for deserting the force, it was given to him, Lord.
My lord can have the date, my lord.
Apprehension roll, he admitted that the apprehension roll was sent to his wife because
No, it will not.
Yes, yes, he has
Yes.
admitted.
Admitted.
But I think it's.
Did your next of kin receive the copy of the apprehension roll issued by the headquarters Tripura Range Assam Rifles? Yes, she received the copy of the apprehension roll.
Malad, the date would be there.
No, it is there in his witness.
No, that there is a signature copy also, Malad, subsequent.
No, this is the part of the proceedings which you have just given it to me, where entire evidence has been taken.
Lordship.
Where he has signed. What action did you take after receipt of the apprehension roll by your NOP? I did not take any action. Are you aware of
And
the
then you
policies
said
and
at that
procedures
point of
regarding
time, you will
grant
come-
of extension of leave during? Yes, I am aware of. Did you inform anybody at the headquarters your inability to join the duties due to your sickness? No, I did not inform anybody. Now here, as regards the document which I have said, here it says your leave including 10 days extension was up to 12/11/2020. 2000.
2000.
You fell sick on 10th of November 2000.
Hmm.
Then why didn't you ask for further extension? That I was not sure whether the extension will be granted or not, and hence I could not apply for extension.
That's his mental.
As per the medical document produced, you were under treatment
Till
of
March.
MO Coal India Limited moderator from
Prior-
7th of December 2000 till the end of February 2001.
One.
Why didn't you rejoin
Fine.
after this period was over? Instead, you rejoined on 24th of
Fine.
March. As I have mentioned earlier, I was not fully recovered by the end of February 2001, and after that, I have been taking herbal treatment from a local doctor. Do you have any certificate
Doesn't
or
have.
med documents from the local doctor by whom you were being treated with herbal medicine, or for village authority to prove that you were really sick and were under treatment with effect from so and so? No, I don't have.
Don't have.
Then,
So they boiled down till March. March 1st to
no,
24.
not March, from February.
No, Malad,
2021.
February last, that means 1st of March till 24/3. That's the period, Malad, they say he could not show anything, Malad.
You should have asked for extension. Why didn't they?
That's not true, Malad. Because his
Because these
psychosis,
are,
alcohol, Malad, he's a gone case. Malad.
Understood, but main problem, Mr. Nair, arises because of recent Supreme Court judgment, servicemen, government and all.
On Friday also,
Friday
there was
also.
a judgment.
Every day there is a
My lord, that
judgment.
is unauthorized. If there is some cause, my lord, then my lord, they'll have to look into.
What is
because,
the cause?
my lord,
He
see
himself
those
says that I
certificates which have been
didn't.
exhibited, my lord. Certificates which have been exhibited.
Understood that certificate has been duly taken note of and
That
said
means, my
that
lord-
you were there till February 2001.
One,
Right.
from March,
You asked for extension.
my lord, I did not. So, my lord, from March 1 to March 23, that's the period, my lord, which is of absence, which is unexplained. My lord. But he gave an explanation that he was not fit. He gave an explanation that he was not fit. They have not taken any steps to either examine him medically to find out whether he was, my lord, really suffering from that problem. They have done nothing, my lord. They have taken those documents on record, certificates on record, and my lord would find in the order,
But
We
Mr.
have
Nair, tell
not-
me, why did he join on 24th then?
my lord, because the main thing was, my lord, he was retiring on 31. That was the reason.
Huh?
31/3/2001, his voluntary retirement was coming into force. So
Why
he
did
joined
join
back.
on 24th?
Lordship,
Why did he join on 24th?
because 31/3/2001 was his date for voluntary retirement. And my lord would see all these proceedings
Who told you?
because that's
told you
that's the
Have
order.
you
my lord.
stated in your petition?
No.
Then
That's the only thing that
I
can
hope
happen.
you
my lord.
don't speak to ghosts nowadays.
No, my lord. But that's the only thing that can happen, my lord.
Then how is it possible you are telling all these things?
My lord would see, they instituted this proceeding on 25/5/2000. My lord, some penalty, yes, my lord, because of the forced thing, but not the thing which will have the effect of, my lord, depriving him of and his family of the pension. Once you had taken a decision. And there was
I
something-
have all the sympathy
I
for
know,
you all. But Fact is, give me a handle.
My lord can, the handle would be, my lord, if lordship comes to 17, there are two penalties. There are two penalties given, page 17.
It can be.
Yes. One is reduction.
Two riflemen and the other is dismissal. My lord will retain that.
Then?
Retain the penalty of reduction.
How?
Because my lord will only see that portion that he has explained, that my lord was not gone into. Proportionality, my lord. That was not gone into. If that was not gone into, they will have to. Proportionality would come in. It was never taken into consideration. That
Proportionality means the problem arises, these are discipline services. What to do with that?
my lord, discipline in service, what they are saying, my lord, that he is a clerk. He's an office staff, my lord.
Discipline is discipline. Where is the dismissal order? Means.
Page 17.
No, not that one. Where is the decision-making process for that?
Nothing, my lord.
Whether anything was sent? Or how is it done in this court?
They took it and they passed this order, my lord, page 17.
The finding was their lordship page.
Finding of sin.
Answers.
Where is the finding?
Page 6 of that record, lordship.
Page?
6. From the bottom, backside lordship, backside
Or it is backside?
lordship. After the witness statement of findings.
Having examined and gone through the facts of the case, the court of the opinion.
The finding of
extended himself without any incident, right, unconstitutional. It could be in the- You also didn't give any evidence.
That only his statement was recorded.
Huh?
Summary manner they did it.
Now let us see his witness. What is his evidence? Because granted 15 days case will different. Before termination of the leave, I applied for 10 days extension on with effect from 7. I felt sick with fever and vomiting and so on, so I treated locally and medically. Whole India hospital, there were diagnosed effective hepatitis. Then I was discharged from hospital.
What's the idea?
He himself says, even after completion of the house course of treatment and rest as advised by the MO local India, Coal India,
Polling.
I was not feeling completely recovered and weakness was still continuing till February 2001.
No, subsequently he said.
That is what. I left house to rejoin my duties on 22nd March 2001 and reported
On 20.
at HQ so and so on 24th at around 24. So he himself says in his evidence that after I was not feeling well till February. Later on, upon cross-examination to him, he further says that I was then also not feeling well.
March.
Yeah, but he was asked, do you have any papers to that effect?
No, he
There's
doesn't.
nothing.
For the month of March treatment, he has nothing. Nothing.
So how do you take care of that?
Only thing, my lord, if my lord finds that aggravating situation, alcoholic psychosis, which he was suffering from, it's a continuing thing, my lord. It cannot go away in a day. It's a continuing thing, and it normally, my lord, it deliberates the man. He cannot think rationally.
How did he die?
Liver cirrhosis, I think so.
You have put the death certificate somewhere.
Somewhere there. Yes, yes. Huh?
IA file.
There is an IA file, my lord.
Substitute.
Oh,
Yes. It's not there in the, he died in the hospital, AMC Hospital, Dibrugarh. But I think it was, my lord, something of that sort of. Oh,
Nothing out here.
no, in the medical certificate, my lord, it's only that the death is being recorded, but the reason is not recorded. The death is, my lord, in AMC Hospital, Dibrugarh. It's IA number 1091. Whether I have stated that.
So the problem arises, Mr. Nair, how do I help you?
My lord, the only
Very
thing my lord
difficult.
can do for me best is, my lord, that penalty of dismissal be interfered with, the reduction be kept.
How?
Because of the reason that at least that person was, my lord, suffering from alcoholic psychosis, and they had not taken that into account, my lord. They had never factored that in, my lord. They just went,
But that is never your case
No, no.
before that authority.
my lord, that certificate which was produced before.
Understood, but whether he was there till that and thereafter he was under my treatment so and so till February 2001.
One.
And thereafter whether he is still suffering, there is no statement, there is no document.
My lord, that is the
Are you
reason why.
saying that the authorities should have again then also looked into and gone into all
No,
these
if
things?
the authority, my lord, is saying that 132 days I am absent, that's why this punishment. But my lord, from the records, my lord would find that 132 boiled down to, my lord, 22 days.
No, it is not 20
From March.
days. No, nothing doing to you. You have not, it is unauthorized leave. Unauthorized leave, you have not there.
Unauthorized
You did
without
not,
cause.
you got this certificate on 23/2001.
Hmm.
If you got this certificate on 23/2001 and then on that very day you travel to,
No, 2 days thereafter,
yes, thereafter you
That-
take this and then you travel to your station.
station.
Then why didn't you get it till then?
My lord,
That I'm
that's,
suffering.
my lord, that's the bona fide he shows, my lord.
Huh?
No, if he wanted that, he could have done it, my lord. He did not. That's why, my lord, alcoholic
He did it,
psychosis person, he is not in a position to
No,
think,
no,
my lord.
no, that's too
If it was
far-fetched.
any other person, they would have got a certificate till 23/2001.
Oh, Mr. Nair, I have all sympathy, but. the
No, my lord,
problem
the only
arises.
thing my lord would see,
This court, how can this court look into it, all these things? You have not, you have got this certificate, everything is looked into.
Fine.
Yeah, he was asked, but there's nothing out there.
but my lord, one thing, he got the certificate on 23/2001. At least.
Now,
one-
did he say as in his witness that I'm still suffering?
my lord, he-
He never said, you have a look.
my
I'm
lord,
coming
there's
in
one
5 minutes,
statement
have a
that-
look.
there's
And you
one
show me that he's still suffering. There's one statement in his witness. I'm coming in 5 minutes.
Lordship.
Hmm? Is it heard by?
Item number 7. There's the partner.
Is it recorded out there in the part heard?
Partner has not been recorded.
So, no part heard. Yes. Yes, did you find anything? There's nothing.
My lord, that page 6, I would only have page 6 and 7. My lord, leaving aside everything, my lord, finally they come down to last line, that from March 1 to 23, he could not explain, produce any documents. Now, my lord would turn over to the next page. Conclusion is 132 days absent. So, my lord, if it was for that 23 days only, wherein he could not show cause, my lord, others they have accepted, then, my lord, the penalty should have been lesser. The penalty should have been lesser. Because, my lord, what they are saying, 132 days, you are absent, you are not there. But finally, they accept the other
I took
things.
key judgment decision.
2001 9 SSC 592, where lordship court should not interfere with the punishment. Union of India versus Arbitration.
Each facts, my lord, have to be seen, my lord.
Seen. Here it is when justified. Interference is, it was held lordship. Para 13, paragraph 13 lordship.
You are saying about 2001.
Yes, your lordship.
Mr. Roy, is there any, have you taken into account the earlier circumstances?
Yes,
at all?
Yes, it was, earlier it was also habitually.
Where?
that four red entries, this was the fourth red entry, fourth red entry, the present offense. So they have taken into account the earlier three red entries and this, and then they passed it on.
Oh, then that
No,
is
there
the
is,
way
there,
out.
no, there is a Supreme Court judgment of that. My lord, we'll have this one. Four red entries, what happens? It's not automatic. It's 2019, 9 SSC 253. Is it? Achha, trying to base my submission on this.
To make on light use.
2019, 9 SSC 253.
A2 light. A2. Accept police. Yes.
My lord would have, this is my lord basically with regard to that four red entries he was given up. My lord would have page 255, para 6.2, my lord. We have gone through the 4 red entries and the nature of allegation and charge on the basis of which the 4 red entries were awarded to the appellant. It appears that out of the 4 red entries, 2 red entries pertain to 394 and 1 red entry pertains to 3594. Out of the aforesaid, with respect to one of the red entries, the allegation was the appellant refused to take food when he was ordered. Considering the nature of offences which the red entry are made, we are of the opinion that the basis of such red entries, the appellant could not have been discharged from service, and that too after rendering 13 years of service when he was about to complete the pensionable service. From the impugned judgment and order, it appears that the appellant has been discharged from service mechanically and solely on the basis of award of 4 red entries. As observed by this court in so and so, mere award of red entries do not make discharge mandatory. It is further observed that the 4 red entries is not some kind of Lakshman Rekha, which if crossed would by itself render the individual concerned undesirable or unworthy of retention in the post. Award of 4 red entries simply pushes the individual concerned into a gray area where he can be considered for discharge. But just because he qualifies for just discharge does not mean that he must necessarily suffer that fate. It is further observed that it is one thing to disqualify for consideration, an entirely different thing to be found fit for discharge. It is further observed that 4 red entries in the sense makes the individual closer to discharge but does not push him over. It is axiomatic that the commanding officer is, even after award of such entries, required to consider the nature of the offense for which the entries have been awarded and the other aspects. It is further observed that the authority exercising the power of discharge is expected to take into consideration all relevant factors. That an individual has put in long years of service, giving more than not the best part of life to the armed forces, that he has been exposed to hard stations, difficult living conditions during his tenure, and he may be completing pensionable service, are factors which the authority competent to discharge would have even independent of procedure been required to take into consideration while exercising the power of discharge. This is important. Coming then to the case of hand, we find that there is nothing on record to suggest that the authority has taken into consideration the long service rendered by the appellant. There is nothing on record to suggest that the nature of the misconduct leading to the award of the so-and-so was so unacceptable, and the competent authority had no option but to direct his discharge to prevent indiscipline in the post. Even considering the offences for which the red marks were awarded, it cannot be said that the misconduct and offences are such that it would discharge the discharge of the appellant. The offences are for red entries, for which red entries are awarded, cannot be said to be such gross misconduct, which would make the appellant undisciplined and liable to be discharged from service, and that too after a period of long service rendered by him. And accordingly, my lord, that was interfered with, and he was directed to be paid pension.
Now show me here what has happened as regards his habitual thing
My lord would come to page 17.
of
Page 17 of the report. Therein, my lord, there is the record. I did not find anything. The order is there.
The second paragraph, the individual is a
Page 17, my lord. The individual is a habitual offender as he has overstayed leave on 3 occasions in the past, for which he was punished to amend his attitude. But again, he overstayed leave for 132 days without input to authority. But my lord, there was a reason, sufficient cause which was shown, at least for the majority of the period. My lord, for 23 days, he could not produce any documents. He said something. He could not produce any documents. The authorities, my lord, did not even consider that. They mechanically went, you are leave for 132 days, and they kept this in back, my lord. They did not bring this 4 red entry thing here.
no, his punishment was the charge against him was for unauthorized absence of
Once.
132 days.
Only days. But this earlier proceedings, earlier thing was never there in the original proceedings. It came only when it was awarding
No, that is at the time of taking into account the punishment.
punishment. My lord,
They have taken into account that earlier also he has been a habitual offender.
my lord, that the normal rule is that that also should be made a part of the proceedings. my lord.
Not necessary. Here you see. This is a case of 108
8
days.
days. On Friday, it was.
Where is the earlier period? Where have you mentioned about this? That earlier also he has been indulging. in-
That is, my lord, in page 17, that para 2 only.
No, that is there, but.
But
where
there,
is-
my lord, in the records, I have not been able to.
In the record, it was not there, Lordship.
Record is not.
Required, Lordship, can you please the. Because this was for that court martial, summary court martial.
We have it on 8. Get your instructions on this.
8.
The incident with petition has been filed. Challenging the termination of the petitioner, the dismissal of the petitioner by the order dated 2/6/2001. In the said order dated 2/6/2001, it has been mentioned that the petitioner was a habitual offender as he had overstayed leave on 3 occasions in the past, for which he was punished to amend his attitude. But again, he overstayed leave for 132 days without any information to the authorities. From the records so produced, as well as from the affidavits so filed, and from the records so produced, as well as the affidavit filed by the respondent authorities, there is no materials wherein if there is a mention pertaining to the aspect that the petitioner was a habitual offender. List the matter again on 8,
Lordship. let it-
8,
let it be
2000.
On 11th, Lordship.
What is this 11th? Why 11th? 8. Get whatever instructions you have. 8/8/2023. The authority, the respondent authority shall bring on record as to whether the petitioner was a habitual offender prior to the charge prior to be charged for overstay in leave for 132 days. To list accordingly.
This.
Lordship, I
that
take
judgment of
back
the
the.
Supreme Court, Extreme.
Huh?
That judgment of the Supreme Court, it's an extreme case. That's why the Supreme Court. This one. 6 times, my lord, he was there. And he said he's joined on February, whereas he surrendered in May.
No, that is okay, but the thing is, no, Mr. Nair, that is why I want to bring on record. If he is not a habitual offender, they can't sue. Then a leniency can be sued.
But
See, that is,
there might be, my lord, 3 earlier red entries.
red entries may be there, but whether he may be, just for example, he may be for some drunkenness or something,
Like-
that might have been
Lot.
one,
Lot.
but
The
not
nature
for
of-
leave. then something could be done. Otherwise, it's,
My lord,
if it-
then that 2019, that last paragraph would come in nature of your.
that is too far-fetched.
Oblige.
Item number 3. Item number 3.
None appears on behalf of the petitioner on call. It further appears that on 26/2023 also, none has appeared on behalf of the petitioner. Taking into account, it appears that the petitioner have lost interest in the matter for which the instant petition stands dismissed for non-prosecution.
Item number 4.
Yes,
With regard to an order passed by the learner,
award.
award was passed in our favor. Thereafter, the management came before them saying that after the publication of the award, they filed an application saying that it needs to be reviewed. Now, the learned labor court reviewed the matter and against this particular review and the grounds on which the review was done, we are before this honorable court. Initially, one of the ground we urged was the power of review gets lost after the award is published. But recently, I have given a compilation for your lordship with regard to the.
Yes, Mr. Dasgupta. That is your point.
No, it is
Yes.
a settled case, Lord. Yeah, yes, it can be filed.
Eh?
When an ex parte award is passed, an application may be filed for setting it aside.
It was an ex parte award.
It was ex parte award.
Because after they filed their WS, they remained absent.
It was settled in the year 1981, AIR 1981, page 606. Greenlands Bank Limited,
Greenwich.
Greenlands Bank Limited. That's a well-known case, Lord.
It was more like a procedural review.
Yes. Very well read judgment. Procedural review and substantial review, distinguished was made in that judgment. Very short judgment.
I have given a compilation. It has gone to the.
This point is settled.
Given a recent judgment in 2018-16. There is a compilation I had filed, your lordship.
What did you say?
The serial number 8 is the judgment where the debtor's position has been verified. The apex court says that it can be reviewed, but when the management comes, then there should be a check. Your lordship will see page 63 of that compilation,
Page
page 63 of the entire compilation. I have given the last page,
60.
para
Yes,
37 of this particular judgment.
merely because an award has become enforceable does not mean that it has become binding. For an award to be done, it should be passed in compliance with the principle. An award passed denying an opportunity of hearing when there is a sufficient cause for non-appearance can be challenged on the grounds of personality. Award which is
37 and 38.
not be stated by. In case the party is able to show sufficient cause within a reasonable time for its non-appearance. So the court reviewed it.
Reviewed it. Now.
Reviewed means reheard it.
We heard. Now, the ground they reheard it, they say that their only ground which they placed before the labor court was that your lordship will see, there is a provision under the Industrial Dispute Act, section 36.
Show me that order pass, which is the
Industrial
order
Dispute Act,
impugning that order, which one?
the order your lordship will find. The impugned order is annexure A.
Annexure,
A,
page
page, your lordship will find 26.
26.
Yes.
Yeah.
If I may, this is an application passed. This miscase was registered having application number such and such, dated such and such. Now, in the the notice of this proceeding was properly served on the opposite party, the Pankaj Sharma. He has also filed written objection against the same application. The applicant side filed affidavit of Sri Vikas Datta, who was also cross-examined by the opposite side, learned advocate. The opposite side adduced oral evidence of Chandra Das, the senior assistant of the office River Commissioner, and he was also cross-examined by the applicant side, Ashish Das Gupta. After closing of the hearing of the evidence, I heard the argument of the person side and learned counsel for this opposite side. Now, para 3 is the petitioner management states in the pleading of this court, having notification number such and such received from the governor of Assam, registered a case number such and such. The appropriate government asked this court to adduce the dispute between the management and his workers, Pankaj Sharma, setting the following terms of reference. The reference has been presented. Having the notice of the case received by the applicant management, they filed their written statement on 25/9/2008, which was signed by the director, Sri Vijay Agarwal, but they did not pay for leave of this court to engage any legal practitioner, and also did not take any consent of the opposite court for engaging any legal practitioner in terms of the provision of 36(4) of the Industrial Dispute Act. The written statement filed by the applicant management was received by the register of this honorable court on 25/9/8. In the reference case, the workman was represented by the legal prosecutor without taking consent of the applicant complying with the provision of 36(4) of the Industrial Code. The applicant was under the impression that the aforesaid reference would be held after due compliance of the provision of section 34, and they would be intimated because this is the main ground. They say that they had an impression that after they filed their WF, and both the parties had filed their WS, another fresh notice would be required to be issued to them after either party approaches the court, because 36(4) gives the restraint that no party, just as a family court, your lordship is aware, it is not a matter of right, legal practitioner can represent the party. So their contention is, after they filed their WS, they remained, it is admitted. They say that it was the impression of theirs that they would be given another notice after the workman would have sought for a liberty to engage in counsel. Now, that is not a requirement of law for issuance of a second notice. That is their only ground, saying that they remained absent because they means it is an admitted position, they appear and they stopped appearing. And the court awaited for them, and if your lordship sees the order sheet which we have annexed, they remained absent throughout the proceeding. Now, this is the only ground the court comes to a finding that this may be a ground for. And then this on 4/3/2010, applicant received a letter of authenticity, which was sent by, whereby the applicant came to know that the ex parte award in reference piece number has been found. And the said letter was accompanied by a copy of the ex parte order award dated 37/2009, through which the applicant was directed to reinstate the opposite party and pay him the back wages, etc. within 3 months. From the ex parte award, it is seen that the opposite party was represented by his advocate in the reference case, and Mr. Such and such was shown to be as representative of the applicant. The applicant at no point of time engaged in legal practice. There were no negligence or laches on their part in not appearing before the honorable court on the date fixed. They were of the impression of certainty. Now, I will take your lordship directly. Now, these were the arguments that was placed, your lordship. Now, the finding, your lordship.
Show me the award, ex parte award.
Pardon, your lordship.
Where is the ex parte award?
The ex parte award, your lordship will find. The award, your lordship will find. Award is annexure C, page 46.
Well, in this award below, inquiry was declared unfair. In this award, inquiry was declared unfair. And accordingly, the management should have an opportunity to adduce evidence on merit. There was nothing needed in that award.
Okay, then I'm ready.
46. Yeah,
Who filed the written statement on behalf of the management?
Management, it was filed by the Mr. It was on the record, it was found that one advocate had filed it on that. Was the filed by means. And
He did not give a wakalatnama.
means, he could not, means,
Where is the record?
the LCR, I don't think it is there. I checked out, it is not there. But, in the award, it is mentioned also, represented.
Evidence on affidavit. Because I take this thing, he has filed an evidence on affidavit. In the evidence on affidavit, he was identified by a lawyer.
Who has filed the
Probably
evidence?
the
On-
court was under impression that that lawyer is representing
No. Who has filed the evidence on affidavit?
the employer himself. One
Management.
Pankaj Datta, no?
Some Agarwal, I think it was there in the initial.
Then how he had due knowledge if he had filed the evidence on affidavit?
Your lordship may kindly tell you.
When he had filed the evidence on affidavit, he had due knowledge about the proceedings.
Yes, he was the due knowledge. of
Then
the
why is it
proceeding.
necessary?
But actually, what is his contention is that section 36(4) states that if any party may engage lawyer. So for the purpose of engagement of the lawyer, a leave of the other party is required to be taken, or the court shall pass an order in this behalf. And he was under impression that as the lawyer has been engaged by the workman and the management has not engaged any lawyer, the court will pass an order in this behalf, and then and only after then the proceeding will proceed. Because in view of the provision as contained in subsection 3 of the section 36, Lord,
Hmm.
no party to a dispute shall be entitled to be represented by a legal practitioner in any conciliation proceeding under this act or in any proceeding before a court. Subsection 4 states that in any proceeding, labor court, tribunal, or national tribunal, a party to a dispute may be represented by a legal practitioner with the consent of the other parties to the proceedings and with the leave of the labor court. That portion, with the leave of the labor court. With the leave of the labor court or tribunal or national tribunal. And in fact, Lord, it appears to me the labor court was under an impression that the management is being represented by a lawyer. And for that purpose, Lord, this leave was not granted. Or the labor presiding officer did not think for grant of the leave. And here also,
Their contention is in page 63 in their application, your lordship. Page 63 is the application they filed seeking to be. That is annexure F. It starts from page 61. Where they have
Understood,
filed-
everything is understood, but why didn't you participate? He may take leave or he may not take a leave. That's a different thing. That is for a workman. But how do you explain that why you did not participate? There is no notice to be issued to that effect. And the court did not ask for that. You see, the reason why the court says that, look here, I have only asked them to file their written statement. I did not say that they are to appear thereafter or disposal, whatever may be. But when the order was passed after filing of the written statement by the court, when the management was very much present, isn't it the notice of the management, what is the next course of action to be taken?
so in this case, the management, workman is being represented by a lawyer.
Maybe.
And
You
for
could have
that purpose,
objected.
they have to take a leave of this court. If the court grants a leave, then and only then he can engage, because the management has not engaged any lawyer. Management wants to engage.
The management has not engaged lawyer, but the management was very much present. So management was very much aware.
So, yes, management was aware.
If
because
the
not only
management was
present,
very
management-
aware, now
management-
tell me, when you moved this application, did you take the leave before the trial court? This application, this review, did you seek the leave?
How can I take it below? Because the award has already been passed.
Understood, but did you seek the leave? If we go as strictly as per 36.3 and 36.4, you had to seek the leave. You couldn't have filed this IA or the review application because it's a proceedings.
Because the award has already been passed.
But then also you are filing it in the proceedings. The word is in any proceedings in a court. In any proceedings before a court. If that be so, then did you seek the leave?
No. I have not. Yes, I understood. If for that purpose, Lord, we have to go through subsection 4. Subsection 4 states that in a proceeding before labor court or a national tribunal, a party to a dispute may be represented by a legal practitioner with the consent of the other party.
Hmm.
Now, Lord, the other party has to give the consent, otherwise I we can file.
And there is an end.
And for that,
And
with the consent of the other parties, to the proceeding, and with the leave of the labor court.
so you need the twin requirements. The twin requirements. One is the no objection from the other side, as well as
I have
also.
given, because I filed this application.
But did you seek a leave that for representing you?
The consent of the other parties to the proceeding and with the leave of the labor court. The order sheet, what order sheet say?
Kashif, I have placed the order sheet before this honorable court. Annexure B1, the type, and annexure B is the original. From page 42, your lordship, the type part, your lordship will find that in the second page, page 43, 29/9/2009, this is the date when the management files their WS with the copy to the workman. Now, thereafter, from the very next date, your lordship will find the management remains absent. The original,
Oh, no, that is remaining records are not there. It is up to 24/2/2008.
this is the certified copy of the lordship. There is the type copy I have given.
It is up to 24/12/2008. Subsequent.
24/12/2008 is the
Understood,
when the
but-
proceeding.
But the fact that the management knew, you could have very well objected there. That how can he appear, be represented by a lawyer? Why didn't you object? You are taking the benefit under 36.3 or 36.4. You could have very well, but can you say that where's the question of no again fresh notice? No fresh notice after filing of the written statement.
Because this is the mandate of law, my lord. No party to a dispute shall be entertained to be represented.
So
No.
the same,
By a
the
legal practitioner.
same applies when you file your review also.
Review was entertained.
Understood, but why? You couldn't have appeared. The review order is passed at your behest. You are the lawyer. Did you take the leave?
That is not there.
No, the order, the review order shows. Kindly see page NHIA page 26. Appearance, learned advocate Mr. Ashish Das Gupta for the petitioner, learned advocate A. Biswas for the opposite party.
26.
Page 26. How did you appear without seeking the leave?
And presently, this 36/4 is refer to the larger bench, your lordship, I wanna.
Well, here, the notice to this proceeding was properly served to the opposite party argument, the Pankaj Sharma, and he also filed his written objection against the state application. So
The applicant filed by affidavit of so and so cross-examined and so and so,
cross-examined.
so and so. Now, how did you appear?
I filed an application.
But did you file an application seeking leave for your appearance as a lawyer?
I will forget to leave the application. Yeah. This work was report passing. This work was report passing.
Record is in here.
Work was report passing. 15 years back.
Now what has happened? What is the
No,
state
Lord,
of?
one thing, but yes, there might have some possibility. One thing that I have understood, Lord, if your lordship goes to page 55, paragraph 10.
Hmm.
Page 55, paragraph 10. Again, if your lordship will set aside this order, then also, my lord, I can file a writ application before against this award. Because it will not be barred by limitations. Now, my lord, if your lordship goes to page paragraph 10, what is the as it is found that the domestic inquiry is unfair. One thing is that domestic inquiry is unfair. Now, what is the law under for the industrial law dispute is concerned? Your lordship is fully aware of this Rudbut Singh's case. That if a domestic law inquiry is declared as unfair, then management shall be adduced to shall be offered the opportunity to adduce evidence on merit.
But management was not present, your lordship. That is the observation of the court in the para itself, my lord, is referring to.
If I'm not wrong, Lubut Singh case says that the management can take the plea that the domestic, as regards the fairness first, as a preliminary and objection, as regards the fairness of the domestic inquiry.
Hmm.
If it is found thereupon, when that is there, then an opportunity would be given.
Hmm.
This is also happened in Gleeds also, in the Gleeds.
Subsequent case
Then it
also-
becomes open.
Hmm.
The moment it is held to be unfair, it becomes open. But you were not there.
It is
When
has
it is
become unfair.
it is the requirement of law that did you take it in your written statement about the fairness of the inquiry? Domestic inquiry. You filed your written statement.
Yes, I filed that.
Did you take the plea of fairness of the domestic inquiry? Now, another consequence is you have dismissed him without serving him a copy of the inquiry.
Yes.
Can you
That
do
is the
that?
advantage.
Can you do that?
Inquiry report. So they were prejudiced. They were prejudiced and accordingly the inquiry.
The
was
dismissal
declared
becomes
unfair.
bad.
Inquiry was declared bad. Look,
No, the inquiry won't be bad. The inquiry may not be bad, but not serving a copy of the inquiry report, wouldn't that amount to a prejudice being caused?
Yes, that is, they have to come explain it. They have to explain it. It is their bargain.
No, they have categorically stated in their written statement that you have not cross-examined him on that aspect.
No, all right. It has been prejudiced. For that reason, fresh inquiry has to be conducted. And generally, so for the labor.
But if a fresh inquiry it may be a thing that you may be giving him the inquiry report. That is another aspect of the matter. But the fact that you have not given him an inquiry
And they have,
and
they were,
dismissed him,
and they
wouldn't
were
that be a
prejudiced.
violation of the principle?
They were prejudiced.
And as such, what happens to him?
Yes.
Is he not
According to
be
him,
reinstated?
as the inquiry report was not furnished to them, so they were prejudiced. So inquiry should not be taken into account. So if the inquiry is not taken into account, how the evidence recorded in the inquiry can be taken into account? And that was done here.
No, irrespective of why should we look into those all other aspects of the matter when the
Because-
fact arises out here that you have dismissed him without giving him an inquiry?
Look, look, so far the labor case and the service case is concerned, there is a basic difference. In the service case, once the inquiry is declared unfair, the generally court declare that you hold the inquiry de novo inquiry. That is the service case. But so far the labor case is concerned, instead of holding de novo inquiry, the court undertake to hold an inquiry to save the time. And so for that reason, my lord, the management is called upon to adduce evidence, if any, they want to adduce.
But you are not there.
Because of the fact that ex parte order was passed.
Ex parte order was not passed there.
Yes.
First of all, you have to raise it as a preliminary issue. You have not raised it in your appeal as a preliminary issue.
In the reason statement.
In that WS, they have stated, with regard to this point, your lordship has stated, they have stated, no legal duty is cast upon Habeas Lemitiu to furnish the same to Pankaj Sharma as no prejudice was caused to him.
Yes.
It is just.
Why?
and before the WS.
Are you not relying upon the inquiry report for dismissing him? But have you raised? We are taking again at 2. We'll take it up at 2. Yes. So don't appear, I'll dismiss for default. Okay.
This is the copy.
Very senior counsel, he expired. Actually, I don't have any contact with my client. And the papers are also, all papers are also not with me. But in the meantime, if the lordship allows me, then I may contact my client, or I may take papers from him also.
For what?
He is my neighbor, I can take papers, some lower court papers. 2 or 3 days time.
But what has happened out here, this matter has to be brought to an end. Because
Now, let the matter be kept apart.
from 2011 onwards, he's out of service. Is he in service because that was set aside? Now, what has happened to the labor court proceedings?
That of course, I think.
There must have been a stay. There stay.
There is a stay with regard to this particular order.
All further proceedings are stayed. So that reference has not been decided till now. Then why does this court have to decide all this?
The issue is not that complex as such, your lordship, with regard to the thing. It is with regard to the technicalities they are raising. With regard to that, they had an expectation that 36(4) would have to be complied with. But it is not a mandatory requirement from the labor code to accede to any request. It was their duty for both the parties to attend the proceeding from the date they received the notice from the court with regard to the referee. Now, willingly, they,
Concept of that the labor court will again issue a notice is totally foreign.
there is no
That
such
is not-
requirement, even the
That is completely foreign. And the reasons assigned out there that it was to be that notice after filing of the written statement, everybody is to be heard and all this thing. That is no party to a resist shall be in any proceeding to and fro. It's a reference case. It is your responsibility to protect the order.
Because as in a civil court also, Lordship, after, in a civil court, when the defendant is given the notice, it is not required that after WS fresh notice.
No, that is not it. And the reasons assigned Mr. Dasgupta is not proper.
So for taking of leave is concerned, there is no such specific order. I have checked from the annexures. But one
No,
thing
there is
that
no
appears,
proper order,
page
but how did, if that be so, if that is your contention, then on what basis did the labor court exercise the power of this power for the purpose of setting aside the award? And when you appeared, did you seek a leave? You appeared.
your lordship may come page 73. No, though it is not specifically mention of grant of leave. That's the order dated 7/7/2010. Both sides are present today. After hearing both sides' learned counsel's submission, I decide the parties are required to adduce evidence according to their respective contention. So the next date will be for
So
filing
same,
evidence
no
in
leave.
affidavit.
No leave has
Implies
been
that he
taken by you.
granted leave.
No leave. So if you raise that issue of 36(4), how did the court take into account that the entire proceedings is wrong then? Unless you challenge that award. So this has to be brought to an end. It's happened in 2008. And you understand, you have been always, you mostly appear for workmen also.
I am in the awkward position. But this gentleman, Mr. Omora, he always appears against me in Guwahati. He requested me to take this matter. Well, I will already agreed upon. Thereafter, all of a sudden he died.
Because it is deemed. If somebody appears to the lawyer, it is deemed. Nobody questions. I've seen out there in the labor court also, nobody questions, nobody seeks a leave also. This is always done. Nobody points out this 36(3) and 36(4).
So let me intimate the matter to my client at least. They are not also aware. 2 or 3 days time or 7 days, let the matter be kept as part. I also want to go want to get rid of this case.
No, this, you will get rid of on next Thursday.
No, more days.
No.
Next week.
Dispose of the matter.
Let the matter be kept as part.
No,
Lordship, I request the Lordship to take up the dispose of it.
I'll take it up next Thursday. You want some instruction, let him take, but on next Thursday, this matter is coming to an matter. The matter has been heard at length.
Next Tuesday.
No. Mr. Dasgupta,
That will I can contact with my client.
senior counsel seeks to take some instructions in the matter, taking into account that this is a matter of 2011. The matter is directed to be again listed on 3rd of August. for further consideration. এখন কিয় চলি আছে? এইটো কি? কি বেয়া হৈ নাযাব নেকি? Yes, madam.
They're not no longer appearing in this matter. So they're no longer appearing in this matter. So have-
Yes. What is the matter about?
Lordship may kindly reduce the office from dated 31/7/2023.
Yes, Mr. Gogoi. What is there in this case any further? Huh? Nothing survives in this matter.
Here, workshop Kalasi, whether he has been regularized or not, my lord, again.
No, no, first and foremost, where is the question of promotion? Huh? See, kindly see this order on 13/6/2011,
My lord.
page 45. There was an order passed on 1/8/2005, whereby she was reverted back.
Right.
Now, pursuant to that, there was a challenge to that order. That in the event of any, here what the court says, has annexed a copy of the seniority list of so and so. Feels that the post of LDA is to be managed by work charge khalasis, they will have to make necessary arrangement in the account of it. In view of the above, both the petitions are disposed of, providing that in the event of any decision to promote the work charge seller to post of LDA, the authority shall do so strictly adhering to the seniority position indicating in the rear. They will also consider whether the work charge khalasis are entitled to get promotion to the post of LDA.
My lord.
The interim order dated 3 months shall stand vacated or may pass appropriate order taking into account the cases of also and consistently with the observations made. So I submit that since the order speaks of recovery of the salary, but having regard to the facts have discharged so and so, it is hereby clarified that they will not be entitled to make any recovery from the salary. Now, that was the order passed. Pursuant thereto, the order was passed to that effect. Another order was passed.
Well, there is a speaking order at page 43.
Page 49. But this order has been put to challenge. Page 49.
In the writ petition, it is only page 40.
No, no, no. You are looking into some other.
My lord.
I'm saying about Anita Haldar.
Yes, my lord.
Page 49.
The speaking order, yes, my lord.
So this is the speaking order which
Yes.
has been challenged.
My lord.
Now, this is an order which has been passed in consequence to that earlier order.
Yes, my lord.
So unless that earlier order remains, nothing remains.
Okay.
Where is the question of natural justice, anything else? This is only a consequential order. Now the question is as to whether the petitioners are there or not.
No, the here, my lord, this speaking order has been passed pursuant to the order dated 26/2011 passed in the writ petition.
Understood.
So
That
it's a-
is why that order category, in
Well-
fact, that is why I'm saying
My lord.
on 1/8/2005. 1/8/2005, she was reverted.
Yes,
That order was not interfered with.
no,
Having not interfered with, meaning thereby the court have, she has already been reverted. It is only in a case when you take a decision for promoting somebody to the post of LDA
LDA.
from work charge Khalasi, then you are going to take it. Here you have said that Anita Ali being a so-and-so is not entitled to be promoted as such, her case cannot be considered. It is not permissible for the authority to promote any area to the post of area. Considering the above, so is reverted back to the original post. In fact, this order
my lord,
in effect is actually the order of 1/8/2005,
my lord.
which was not interfered with
Not-
by
not
this court.
interpreted. In fact, the honorable court said that, my lord, if there is any drive for promotion, they should be considered as per the rules. So, my lord, this speaking order speaks volume, my lord, they are not entitled as per the rules.
Now thereafter, you file some affidavit or no?
Yes,
No,
sir.
this is a petition. Why the petitions are different? What is this petition? There is another petition. Who has filed this? Anita Haldar. Why there are two petitions? Oh, amended petition.
amend this one.
Why was this amended petition filed? This is, they are asking for regularization. Huh? How can this court give a direction for regularization?
Well, three players, my lord. One is my lord challenging the speaking order. Other is my lord to allow the petitioner to work as LDA from 39/2004. So my
Yeah,
lord,
that too
from this
not-
player, it is apparent that she was not working as my lord LDA. So that
No,
reversion
she
order-
was there, but she was reverted back.
Yes, reversion order was in effect.
And that reversion order was not touched upon.
In fact, my lord, it has not been put to challenge in the amended petition.
No, they actually challenged it.
Thirty-nine, 2004 is the order whereby the petitioner was allowed, given the promotion as LDA.
The instant writ petition has been filed by the petitioner, assailing the order dated 27/6/2011, issued by the Executive Engineer Public Works Department, bracket Roads, City, Division 1, semicolon, for a writ of mandamus, thereby directing the respondents to allow the petitioner to work as the lower division assistant in the office of the GK subdivision in terms with the order dated 39/2004, as well as also for a direction upon the respondents to regularize the services of the petitioner as work charge and promote the petitioner into the post of grade 3 by appointing her as LD assistant in the office of the Executive Engineer Public Works Department, bracket Roads, City Division. The facts as could be discerned from the writ petition is that the petitioner was appointed as a work charge Khalasi in the year 1994. The petitioner thereupon, in the year 1997, passed her Bachelor of Arts examination. Subsequent thereto, the petitioner filed a writ petition being WBC number 4253/2004, wherein the petitioner claimed that as she was a graduate and there were approximately 6 vacancies in the cadre of LDA, the petitioner be considered for appointment as grade 3 employee as per the government policy embodied in the letter dated 25/5 to 1992. Full stop. The same petition was disposed of by the order dated 22/6/2004, thereby directing the respondent authorities, particularly the respondent number 3, namely the executive engineer PWD R, bracket R, Guwahati City Division, first to ascertain the number of vacancies in the cadre of LDA required to be filled up by promotion under the government policy, and thereafter to fill up the same by promoting the grade 4 employees having requisite qualification. It was further observed that the petitioner, being a graduate, is entitled to be considered for promotion under the aforesaid policy, and her case shall also be considered along with other similarly situated eligible persons in accordance with the provisions of law. It was further directed that the representations were submitted by the petitioner on 8/6/2004 shall also be taken into consideration while making appointment to the post of LDA. Thereupon, on the basis of the order dated 22/6/2004, there have been certain interdepartmental communications on 39/2004, an order was issued by the executive engineer PWD bracket Rhodes, whereby in pursuance to a letter issued by the Undersecretary to the Government of Assam dated 29/9/2004, as well as the Finance Memorandum dated 19/3/2004, the petitioner was temporarily promoted to the post of LDA and placed in the GK subdivision in the scale of pay from the date of joining in her promoted post until further orders. Pursuant thereto, the petitioner joined her promotional post. The executive engineer PWD bracket Rhodes issued a show cause to the petitioner on 29/7/2005, wherein it was mentioned that as there was no rule for promotion of work charge persons, why she should not be reverted back to her original post. The show cause reply was directed to be submitted within 2 days. On 1/8/2005, the petitioner sought for time on medical grounds. Be that as it may, an order was passed on 1/8/2005 by the executive engineer whereby the petitioner was reverted back to her original post. This order was put to challenge by the petitioner in WPC number 5492/2005. Full stop. This court, by an order dated 19/8/2005, had stayed the said order. And it was further directed that the petitioner be allowed to continue in the post of lower division assistant. It is further seen from the records that the said writ petition, so filed by the petitioner being WPC number 5492/2005, was disposed of with another writ petition being WPC number 4366/2006-9, filed by another writ petitioner, filed by another person. Was disposed of by an order dated 13/6/2011, along with WPC number 4366/2009, filed by another writ petition, another person. It appears from the said order dated 13/6/2011 that the said order dated 1/8/2005, by which the petitioner was reverted to the original post, was not interfered with. This court, however, directed the authorities that further, this court, however, directed the authorities that if the said authority feels that the post of LDA is to be manned by work charge Khalasi, they will have to be make arrangements taking into account the seniority position of the work charge Khalasis. This court further directed that in the event any decision is taken to promote the work charge Khalasi to the post of LDA, the authorities will do so strictly adhering to the seniority position indicated in the seniority list. And also would consider as to whether the work charge Khalasis are entitled to get promotion to the post of LDA. It is further relevant to take note of that this court directed that taking into account that the petitioner had rendered service as an LDA during the period, there should be no recovery made from the petitioner. This order, however, this order dated 13/6/2011, passed in WPC number 5492/2005, however, was not put to challenge by the petitioner. And thereby, the order dated 1/8/2005, by which the petitioner was reverted back to the original post, had attained finality. Pursuant to the said order dated 13/6/2011, passed by this court, the petitioner submitted a representation dated 18/6/2011, thereby requesting that she may be allowed to continue as an LDA. The learned, the executive engineer PWD Roads thereupon passed an order on 27/6/2011 whereby it was observed that the petitioner was engaged as a work charge Khalasi in the year 1994. And being a work charge employee is not entitled to promotion to the post of LDA. And as such, her case cannot be considered for promotion. In that view of the in view of the said findings, it was therefore an order was therefore in view of the said findings, it was therefore ordered that the petitioner be reverted to the original post of work charge Khalasi with immediate effect. This order dated 27/6/2011 was put to challenge before this court by way of the present writ petition, along with seeking the consequential reliefs as has already been mentioned in the previous segments of the instant judgment. It appears on record that the respondent PWD authorities had filed an affidavit in opposition on 23/2/2012. In the said affidavit in opposition, it was mentioned that the petitioner's promotion to the post of lower division assistant from the post of work charge Khalasi was not regular, and as such she was reverted back to the post of work charge Khalasi by the order dated 1/8/2005. It was further mentioned that the order dated 1/8/2005, by which the petitioner was reverted back to her original post, was not interfered with by this court in WPC number 5492/2005. It was mentioned that the speaking order dated 27/6/2011 was in consonance with the prevalent laws, inasmuch as the petitioner being an work charge Khalasi is not entitled for promotion to the post of LDA, as it is not permissible for the authorities to promote work charge employees to the post of LDA. It was further mentioned that only regular grade 4 employees are entitled to get promotion to the post of LDA. And as such, the petitioner was rightly reverted back to her original post, that is work charge Khalasi. I've heard the learned counsels and have perused the materials on record. The order dated, the impugned order dated 27/6/2011 from the impugned order dated 27/6/2011, two aspects of the matter comes to light. First, that the petitioner being a work charge Khalasi cannot be given promotion to the post of LDA. And the second is that the petitioner was reverted back to the post, to her original post. In respect to the second aspect of the matter, The non-interference by this court to the order dated 1/8/2005 by which the petitioner was reverted back to her original post, having already attained finality. The question of challenging the reversion. No. I'm telling only finality. The order dated 27/6/2011 by which the petitioner was again there has been a reiteration of the reversion. Cannot be assailed before this court again. The first aspect of the matter pertains to whether the petitioner, being a work charge Khalasi, can be promoted to the post of the LDA. Nothing has been brought on record to show that on the basis of the existing rules, extent applicable rules, the petitioner can be given a promotion to the post of LDA, which is a grade 3 post, no?
Yes.
Grade 3 post. On the other hand, it is the specific stand of the respondent authorities as it could be seen from the affidavit in opposition also, that only regular grade 4 employees can apply for being promoted to the post, to a grade 3 post of the LDA. Taking into account the above, this court does not find any merit in the instant writ petition, for which the instant writ petition stands dismissed.
My lord, my record have,
Huh?
my record have recorded. My submission may be recorded, my lord.
What submission?
We are no longer appearing in this matter.
What?
We are no longer appearing in this matter.
I don't give your names or whatever may be, that is your lookout. Number 6. Think when?
In this case, they are challenging the
What is this matter?
disciplinary proceeding matter, Lordship. They are
Who
challenging.
recently retired from the post of general manager challenges the penalty order whereby withholding of promotion for a period of 2 years was ordered in pursuant to it. Where is the petitioner?
Lordship, the council put a petitioner expired, Lordship.
Petitioner expired.
Council put a petitioner expired, Lordship. BK Bhattacharya. And
Whether the petitioner is alive or not.
I don't know.
Are you paying the pension?
Take instruction.
Hmm?
Lordship, I picked the matter on Thursday.
Now the petitioner is 73 years old. Does this
At that
remain?
time, 60 years. He was retired on
He retired.
31/7/2011.
You have deprived him of 2 promotions.
Yes.
You have deprived him of 2 promotions. And then he retired.
Retired.
When did you deprive him of 2 promotions? 2008.
Eight.
And why is he challenged so long? Then appellate order was passed, order was passed.
Review order was on 2010. And thereafter he retired.
And when did he retire?
31/7/2011.
What is this review order? Let us see. What was he guilty of?
Lordship, he was the head of the materials department, Lordship, and at that time, one tender was floated, and that time, 3 sister concern has participated, Lordship. He knows about the same, and he has given undue benefit to the state contractor, and accordingly, he was the state contractor was become L1, and thereafter, due to the contractor failed, and for that, around 1 crore was lost to the company, and he was the head of the department.
Okay.
Memorandum of charges was issued is 43 to 52.
What is his ground? Why is he challenging?
He was given all the reasonable opportunity, Lordship, and
Huh?
after giving him all the reasonable.
I am asking you, now think that, yeah, Mr. Kolita,
Yes, sir.
think that you are the lawyer for the other side. Now tell me, what is the ground on which he is
One
challenging?
of the petitioner is that one senior employee was also by CVC, he was also named of in the state report, but he was not.
There were
made as-
no
made-
steps taken against
Yes.
him. Then that is not the ground anyways.
That,
And
that is the basic ground.
something more than that.
But it is not the case that he was not given the opportunity.
An officer.
It's not the
waiting
case that
to
reasonable
against
opportunity
a
was not done.
promoted tender inviting.
Paragraph 29 of the revision Lordship is main ground.
Now, withholding of two promotions, that is the punishment. Now, this order was passed then. Now, if I touch it, if he has retired, what is the effect of this?
He will get consequential because consequential benefits some. He will get some monetary
Now, that means you have to give promotion.
Yeah.
Can you give a promotion now to a retired person?
promotion here, promotion that have to consider.
Now, is the promotion on the basis of consideration or is the promotion on just on the basis of years?
Consideration,
What is the terms of promotion?
consideration.
Consideration of what? Seniority come merit, merit come seniority, what?
Seniority come merit basis.
Seniority come merit.
Yes.
So he has a right to be promoted on the basis of seniority. Let us see the penalty order.
Okay, charges Memo of charge case 43 to 53 Lord. Penalty of minor penalty.
Hmm?
Minor penalty, Lordship.
Minor penalty.
Yes.
Where is it?
Case 294, Lord.
Page
294.
29. Yes. Where?
May I read, Lord? Whereas memo of under rule 25 of the oil
where?
executive case 294, Lordship.
294. Yes.
Whereas memo of under rule 25 of the oil executives conduct discipline and appeal rules 1982 mentioning that here in the article of the charges and other irrelevant matters was issued to you under memo number so and so dated 29 September 2005. It was then decided to hold a formal inquiry and Srimati Deepa Bajua, Commissioner for Departmental Inquiries, CDI, and CBC was appointed as the inquiry authority, and Sri YK Joshi, Manager Vigilance as presenting officer by order dated 2nd November 2005, which was copied to you. After affording full opportunity to examine the evidences in support of the charges and to produce evidences in your defense, the inquiry authority has since submitted the report and findings of the inquiry, a copy of which was furnished to you by later dated 5th November 2007. Your explanation in reply to the above dated 28th February 2007 and 22nd March 2007 have also been received. I have examined an entire matter and materials, including the charges made against you. The evidences produced, the report of the inquiry authority, your explanation on the report of the inquiry authority, and after very careful consideration of all these, I find that the article of
Let
charges.
us see what is the appellate order.
Appellate order page 335.
Page
335.
Then you file the review.
He filed the review. That's page 339. Review order. Inquiry report is page 245. Lord. Inquiry was conducted by CBC. Lord.
Hmm?
Inquiry
Who is your disciplinary authority?
disciplinary authority CMD.
Was it been done by the functional director or the CMD?
Yes, Lord. CMD is the disciplinary authority.
Now, who has passed that order? The initial order. Where that page 200, what did you say?
Is
The
CMD,
first
Lord.
order?
CMD. Lord. 295. Lord.
Huh?
295.
Enquiring authority is this. Then who is that? Where is that order? 295.
95. Lord. CMD.
So this has been done by the
CMD.
disciplinary authority, is
Yes.
right? Appellate authority is the board.
Board. Lord.
So he is also questioning on the question of jurisdiction. So that is, what is the basis on which he is questioning the jurisdiction?
Lordship, we have answered in our paragraph 46, Lordship, case 19, Lordship, in our affidavit, Lordship.
Yes.
That the statements made in paragraph, Lordship, it may be wrongly recorded as 28 because earlier also 28, it's 29, Lordship. 29 of the repetition are not correct and the same are denied. The deponent begs to state that as per the prescribed rules under oil CDA rules 1982, in force at the relevant time, that is in the year when charge memo was issued to the petitioner, for an officer to grade GG, CMD was the disciplinary authority for both the minor as well as a major penalty, whereas board was the appellate as well as the reviewing authority. The instant case which was initiated for major penalty and the petitioner being the officer of grade G, CMD had rightly acted as disciplinary authority. As per the state rule, functional directive.
He was from G or H?
G. 0. the charge memo.
But it has been done by the CMD. CMD had the authority for
Yes,
both
yes,
G and
yes.
H.
As per the said rule, functional director could act as disciplinary authority only in case of minor penalty cases. Although there was change in the rules in the year 2007, but the same was not applicable to the instant case which was already under progress. It is a settled law that there is no illegality if an authority higher than the prescribed authority act as disciplinary authority, provided the charge officer gets the opportunity to appeal before an appellate authority, which must be higher than the disciplinary authority. In the instant case, the petitioner got the opportunity to appeal before the board of directors against the order passed by the CMT as disciplinary authority, which was as per the prescribed rules at the time of the of issuance of charge memo. Hence, the contentions of the petitioner that he has been deprived of his right to appeal before the appropriate appellate authority as prescribed under the rules in force have no legal standing. With regard to the reviewing authority as prescribed in Rule 33 of the Oil CDA Rules 1982, it may be mentioned here that the said provision is inapplicable when there is question of enhancement of penalty by the reviewing authority, and hence charge officer does
So,
not have
Mr. Quinta, what should I do? Dismiss for default or dismiss on merits?
dismiss for default because if he succeed, then he will maybe
Huh?
because as informed by R.K. Sharma Lordship, earlier council, the brief was returned back from him.
The
Maybe
brief,
they
the
will.
brief has been returned. It is his duty to take care.
Dismiss for default, Lordship, then
But dismiss for default, again, this matter will come up. Isn't it? Again, another long. We have already spent 15 minutes of precious judicial time. Isn't it? And you have also prepared. Isn't it? The petitioner herein is aggrieved by the imposition of penalty by the order dated 15/2/2008, as well as the rejection of the appeal, as well as the review by the board of directors of the respondent company. And as such have filed the instant writ petition challenging the said orders. It appears on record that pursuant to a vigilance proceedings initiated by the vigilance department of the respondent company, a charge sheet was served upon the petitioner on 29/9/2005. Whereby certain charges were framed against him regarding placement of orders, grant of extension of delivery time, etc. The petitioner replied to the said charge sheet, stating inter alia that it was not his sole decision to take such steps to he's stating inter alia that it was on account of a collective decision. The order was placed as well as extension of time was granted. However, the disciplinary proceedings was initiated and an inquiry was held against the petitioner and others The inquiring authority oblique the officer bracket IA conducted an inquiry by examining 4 PWs, including one from the Vigilance Department. Pursuant to the completion of the inquiry on 5/2/2007, the inquiring authority submitted an inquiry report dated 2012-2006, holding that the petitioner was guilty of 2 charges and partly guilty of 1 out of the 5 charges without any 5 charges. Full stop. Thereupon, on the basis of the said inquiry report, the impugn order dated 15/2/2008 was passed by the disciplinary authority, that is the chairman cum managing director of the respondent company, thereby imposing a minor penalty of withholding of promotion for 2 years. The petitioner being aggrieved had preferred an appeal before the board of directors. And the board of directors, by the order dated
25/5/2009.
25/5/2009, rejected the petitioner's appeal. Full stop. Petitioner thereupon preferred a review before the board of directors. The said review proceedings were also dropped. by an order dated 18/8/2010. It is under such circumstances, the instant writ petition was filed assailing the orders dated 15/2/2008, passed by the disciplinary authority, the order dated 25/5/2009, passed by the Board of Directors in appeal, as well as the order dated 18/8/2010, whereby the review so filed by the petitioner was also rejected. When did you issue the charge sheet?
Memo charge was issued on 29/9/2010.
So at that point of time, that discipline and appeal rules did not come in.
2007.
From a perusal of the writ petition, it transpires that it is the case of the petitioner that the disciplinary authority did not have the jurisdiction in as much as on 25/5/2007, an amendment was made to the Oil Executive Conduct, Discipline and Appeal, bracket of the OECD, bracket close, rules 1982, wherein for grade G, the disciplinary authority was the executive director, comma. The appellate authority was the functional director, and the reviewing authority was the chairman cum managing director. It is the further case of the petitioner that the disciplinary authority had exonerated the petitioner from all allegations contained in the articles of charges against him. And he was only punished for negligence only. He was only punished for negligence. It is the case of the petitioner that there was no negligence on his part, inasmuch as all the actions were taken as per the prevailing practice and procedure only, and also in time. It was further the case of the petitioner that there was no allegation of negligence charged against him, in the charge memo. It was the further case of the petitioner that there was no loss to the company, nor the supplier would derive any benefit whatsoever arising out of his actions. On the question of proportionality, it was the case of the petitioner. Proportionality on the question of proportionality of the punishment. It was the case of the petitioner that the punishment so imposed was disproportionate to the charges so proved. Inasmuch as the punishment of stoppage of promotion by 2 years over the leftover service period of about 3 years, 6 months at the end of the petitioner's career have been harshest among the 5 officers alleged for receipt / issue of defective pipes. It was further submitted that in respect of other officers, the punishment had been only ranged from censure to only 1 year stoppage of promotion. It was further the case of the petitioner that the memorandum of charges were served upon the petitioner on 29/9/2005, and the report of the domestic inquiry was submitted to the disciplinary authority on 2012/2006. The punishment was imposed upon the petitioner on 15/2/2008. That is almost after 13 months. And this delay has greatly affected the petitioner's chances of promotion on account of which was for no fault of the petitioner, but was purely for administrative delays. Yes, the petitioner I have taken care of. Now you say yours.
Regarding the
Okay, jurisdiction taken care of. What about the other? You have only found negligence.
not only negligence, Lordship, in respect to the article of charges number 3, Lordship, he has committed mistake regarding appointing as a third party for inspection, Lordship.
Huh?
As per the tender, Lordship, there is certain inspection team was prescribed in the tender, Lordship. And if the petitioner, if the contractor wanted to appoint other party, third party inspection team, then they have to take approval from the company. So being the head of the materials department, he is the authority, Lordship. In respect of the one, he has appointed one third party, one Messrs Tuboscope as a third party agency without approval of the company. And accordingly, the third party has given go by clean sheet to the contractor. And accordingly, due to the state, already company has already sold the money to the contractor, Lordship. Economic loss occurred due to the state inspection report.
Now, was it necessary to do so?
Yes, Lordship.
No. Was it necessary to issue to the third party?
Yes, Lordship.
Then if it is necessary, then where is the question of what is wrong with him?
Lordship, he has without approval of the company, Lordship.
Understood,
He-
without approval of the company that he has
Yeah,
done,
yeah.
but was it necessary
Yeah,
to
and-
employ a third party
It is an
contractor?
allegation of he has that party has prepared a fake report. Lordship.
How has the disciplinary authority taken note of? Show me.
It is a Lordship, page 44.
Page
Page 44. It is
44.
44. The article of charges number 3, Lordship.
3. As per clause 2, the supply was required to obtain oil specific for engagement of a TPI agency other than Swen. However, Swen on its own included the name of MS Swen as TPI. while issuing swans without the approval of the management in terms of the action facilitated pathway and engaging TPI other than the mention of the penalty. As a consequence of this, all the cases of the inspection carried out by the claims system. But in now, how has issue number three?
Disciplinary authority discussed in page 179.
79. Yes,
Where it was. As far as SARS in para 2.3 herein above is concerned, it emails that without the specific approval of the management of the competent authority, the CO on his own included the name of so-and-so as a PPI, a third-party inspection logic. Subsequently, when so-and-so conducted NDT at Duliazan on this casing, more than 50% of
who is COO?
SARS employee.
Huh?
CO SARS employee.
COO. Page 181.
150.
Include the name of the superintendent. But this is issue number three. Charge
sir.
3 has been
Yes,
established.
established. And lordship, in respect of that, we have stated in our paragraph 32 lordship, loss occurred due to the same lordship. Around 1 crore lordship, 1 crore 10 lakh.
Sure. Now, what is this? Why about the censure to others and why the petitioner you have imposed upon him the penalty?
Because he is the head of the department. Lordship. He is the approving authority.
Hmm?
He is the approving authority.
You have lost the amount of 1 crore and you have just put a minor penalty.
Yes, sir.
So kind-hearted people.
Oil is kind of
Coming.
lordship knows that.
On the other hand, Mr. A. Kolita, appearing on behalf of the respondent oil company, submitted that at the time when the show cause notice was issued and the disciplinary proceedings was initiated, the disciplinary authority for grade G employees for minor punishment was the functional director, and for all punishments it was the CMD, chairman cum managing director.
Is 340 lordship, they have annexed.
I've seen it. This is why I'm saying. He further submitted that from an order passed by the disciplinary authority, an appeal lies to the board of directors, and the reviewing authority is also the board of directors. So, the amendment which was brought into effect on 25th of May 2007 would, however, not cause would not affect the said inquiry proceedings, taking into account that the charge memo was issued in the year 2005. He further submitted that the petitioner herein was afforded all reasonable opportunities by the inquiry authority and in respect to the charges which have been proved against the petitioner, only a minor punishment have been imposed. Referring to the charge number 3, the learned counsel submitted that on account of the petitioner's petitioner, who was the head of the department in question, the respondent oil company had to suffer a loss to the tune of rupees 1 crore 10 lakhs 51,204.63 paisa. He further submitted that there is no perversity in the said findings. And as such, the question of any interference to the impugned order passed by the disciplinary authority dated 15/2/2008, as well as the appellate order and the review order does not arise. Next. I've heard the learned counsel upon this court have perused the materials on record. From the perusal of the materials on record, it clearly shows from Annexure Z to the writ petition wherein the disciplinary/appellate/reviewing authorities were mentioned under Rule 24.1 of the OIL capital D, Executives Conduct, Discipline and Appeal Rules 1982. From the above, from the said, it can be seen from the said and taking into account that the charge memo was issued in the year 2005. And Annexure Z and the document marked enclosed as Annexure Z was holding the field at that relevant point of time. It is the opinion of this court that there is no jurisdictional error by the chairman cum managing director of the respondent oil company in exercising the powers of the disciplinary authority. In the same way, the board of directors were also the appropriate authority to decide the appeal. Be that as it may, this court also finds no prejudice which have been caused to the petitioner. Taking into account that no remedy of the petitioner have been taken away. As was alleged in the writ petition. Next. Now coming to the merits of the case, it is seen that the respondent authorities, that the inquiring authority had duly afforded the reasonable opportunities to the petitioner And there is a clear finding that on account of the petitioner's negligence, and acting beyond his authority without taking the specific permission from the respondent company. What is this TPIA?
TPA Lordship.
Hmm?
TPA, third party agency. Lordship.
Third party?
Agency.
A third party agent was appointed. For which the respondent oil company had to suffer a loss of an amount of rupees. It is further seen that the petitioner had been only imposed a penalty of a minor punishment, have been only imposed the minor punishment of withholding 2 promotions. Taking into account the above facts and the limited jurisdiction under which limited jurisdiction of this court under Article 2 to 6 of the Constitution, which only provides 2 to 6 of the Constitution, whereby interference can be made to the orders passed by the disciplinary authority in respect to cases which are unreasonable, arbitrary, unreasonable, arbitrary, and have occasioned manifest injustice, comma. This court is of the opinion that the petitioner have failed to make out any case for interference under Article 2 to 6 of the Constitution. Considering the above, the instant petition lacks merit for which the petition stands dismissed.
Highly oppressed.
Yes, Mr. Ali. Yeah, matter. Yeah,
Item number 7.
70 days. Yes, what is the matter about?
Matter is, your lordship. These petitioners, your lordship. They are the owners of 3/4 of land, your lordship, which is landlocked land.
Landlord?
Landlocked.
Ah,
They are the owner of that land, your lordship. So when we purchase the land, your lordship, the vendor said that this part, we are using this the public part from Rupnagar Road, your lordship, on the other side, your lordship, that is on the western side. Rupnagar Road. So that part, your lordship, it runs over the land of STC. Over the land of STC, your lordship, and that part, your lordship, reaches one Ma Monisa Mandir. Ma Monisa Mandir.
so many orders passed. Yes, tell me what is the case now? You have a plot of land.
From Rupnagar Road, your lordship, that is on the western side. There is a part, your lordship, over the land of STC to Ma Manasa Mandir, that is the part, your lordship, used by the public and it is there for last 25 to 30 years. Just on the western side of that Ma Manasa Mandir, your lordship, our land is situated. It is a landlocked. Anyway, but when we purchase your lordship, the land of tender side, that this is the part we are using from this plot of land to the Rupnagar main road. And your lordship, that part, your lordship, leads to our land from Rupnagar. Anyway, your lordship. So it is admitted position, your lordship, that STC, your lordship, it is on the STC land. So we are also using, your lordship, that part, your lordship, since the date of purchase in 2018. Suddenly, your lordship, in year 2021, lordship, the STC personally, your lordship, blocked part, your lordship, on our side. As a result, your lordship, we can walk in, and when first of all walking is concerned, but we can't play our vehicles, your lordship. So there was dispute in between the parties, your lordship, civil criminal cases. Ultimately, the ADC, your lordship, I just said that you make a compromise in the matter because we can't decide it. So both the parties sit together and make a compromise. Accordingly, your lordship, that as part of that, we filed a petition before the managing director that we should be given right of way on it. For that, we are ready to pay anything. Only the right of way. So managing director also, your lordship, we considered, your lordship. All right, we agreed that there will be agreement and you will have to pay some amount as decided by the chief engineer, the business superintendent plus other officers, people. And that subcommittee.
Now you have the road or not?
I'm not having, your lordship.
Now how are you, how's your ingress egress happening?
Lordship,
How is your ingress and egress
lordship.
to the land has been,
Walking, your lordship, that is walking super walking is concerned, your lordship.
but not by car?
Not by cart and we can't fly any vehicle. That is the problem. After the Manasa, your lordship will come at phase 80, your lordship.
Yes.
Phase 80, your lordship, that is upper side, it is Rupnagar Road, your lordship.
Hmm.
From that Rupnagar, your lordship.
Page 80.
Lordship,
Yes.
80, your lordship.
Your road is where?
Your
Your building?
this just Ma Manasa Mandir, your lordship is saying.
Yes.
So just after beyond that, your lordship, on the eastern side, that is the eastern side, your lordship, below. Beyond that, your lordship, eastern side, that is my land, your lordship, covered by your it is that number 101.
So you want to enter through this this,
Lordship,
this-
just
this is the road,
correct one.
dark number 115.
That is 115 of STC. So for our that number is concerned, it is 1019 and 1020.
No, which is the road you are suggesting?
This is the road, your lord.
Which one? The one with the side, this one,
From this
is 22 feet.
cross portion, your lordship.
Hmm.
If it is done like a picture is there, if it is removed, your lordship, but that is the blockade, your lordship, they have created. This-
Where? You are referring to this is the road,
Yes, your lordship.
the one.
This is the road from Rupnagar Road on the western side.
So it is 8.2 feet
8.2 meters, your lordship.
or 8.2 meters.
Meters,
It's a
25,
huge road.
25.
And
Twen-
down below
It is down
another.
below, it is coming to the our plot of land, your lordship. After the end, your lordship.
And you don't have any other ingress or egress.
No. So, for that, your lordship, the managing director, your lordship, we agree that you give us a right of way after having been adopted a resolution by the board of directors. So in the board of directors, your lordship, on the, that is the one 178 meeting of the board of directors, that is, it was held on 21/5/2001. So in that board meeting, your lordship, it was adopted, your lordship will come to please.
That 178 meeting,
Yes, lordship.
that has been cancelled subsequently on the basis of media report.
Media report, correct, your lordship. And your lordship will find from the media report,
Yes, Mr. Bora, that's. what-
And they have
How do you
realized
solve the
it-
problem?
your lordship, they have realized 18 lakh from me.
Okay, but you yourself are saying that they want to return it, you are not willing to. do.
Your lordship,
Yes, Mr. Das,
money
how
is
do you
money is
resolve the
matter.
situation?
There is
We are on a question of.
no so-called, no so-called, your lordship, no notice, your lordship, no opportunity of being directly arbitrarily without reason, your lordship, in an unfair manner.
Understood.
And that
No,
was not-
Mr. Ali, all these things are understood, but here is the case of how do you tackle this issue? See, this is a case, barely I set aside that, then I'll have to ask them to take a decision, then they will issue a notice to you, and then the same consequences is going to befall.
No. What they will do, your lordship, that is different here. So for this termination is concerned, your lordship, it is illegal, your lordship, it is violation of Article 40. It is in
So you want the termination to be removed,
lordship.
and then I give them an opportunity
No,
to
there
give
is
you a
no
notice,
question of
and then
giving
they
them
will do the same thing, Mr. Ali.
There is, but this, are there no way your lordship will come, annexation 9, your lordship. There is an undertaking given by them, your lordship, that they will not construct nor obstruct in any manner, your lordship, on the road. That is exhibit 9, your lordship. Annexation 9, your lordship.
This is the agreement.
Agreement, that is that page, that is dated 9691, your lordship, page 81.
So, Mr. Ali, how is this agreement enforceable? How is this agreement enforceable in law?
It is not impossible, your lordship, right of way, your lordship, they are not suffering any prejudice, your lordship, if I use.
Wait, let me see what Mr. Das said. Yes, Mr. Das, how do you tackle the situation? Give us a way out. He also needs an access to his land. What can be done?
Actually, the thing is that the land which the petitioner is claiming is belongs to the government.
No.
Although-
Petitioner is not claiming. The petitioner is only claiming,
Ingestion of
requesting for a right of access.
lordship,
He's only he wants a right of access to the land.
lordship.
That's all. Now, any other way by which he can have an access to the land? That is the question. Can you help it?
Lordship, that I have to take the instruction, lordship, because as of now, the land which is in dispute, it belongs to the government.
No, that is okay. I understand that is a government land having a right of access 25 feet, it will have a serious consequence.
Lordship,
And how much is your land? His land? How much?
Three
Not
quarter,
a
your
solid-
lordship. Our land is 3 quarter.
3 kathas.
3 quarter. Very valuable land, your lordship. And we did not foresee, your
they
lordship.
have
that-
purchased the property.
No, you knew, Mr.
Yes, lordship.
You knew it. When you purchased this land in the year 2018
Lordship,
at 54 lakhs, you knew it.
No,
That
lordship,
3 kathas of land purchasing at 54 lakhs at Rupnagar area is next to impossible. Isn't it?
that is different aspect. your
No,
lordship.
no, either there has to be two things. Either it is a thing that it has been undervalued or shown to have been undervalued,
This is-
or it
See,
may be that because you don't have access to the land,
Correct.
it is this.
That is the consideration.
The third one.
That is the.
So you knew it here. Why did you purchase it?
So when we purchase, your lordship, by this exhibit, your lordship, annexure
I've seen it, page 27.
26 and I guess 27, your
Yeah.
lordship.
So you knew it. How do you get 3 kathas
No,
of
no,
land?
you got it. Matter has been settled, they have realized, they have to sum, your lordship, that is 18 lakh, only for giving the
But
right.
how do you give government land? Means they are going to lose how much land? Mr. Das, how much land you are losing? What is the length from there to this place?
lordship,
And how are people going to the Mamanusha temple?
lordship, that we have already stated in our affidavit, lordship,
What have you stated?
which we have filed
Hmm.
So
What
that
is
is
it?
a part, your lordship.
Paragraph
that
5,
only
lordship.
block for the others,
No.
for the pilgrims are concerned, your lordship.
Oh, yes, para.
Paragraph number 5, Lordship.
Para affidavit file with respond number 5.
Lordship, this is an affidavit final by respond number 1, 2, and 3.
1, 2, and 3. Respond number 5 is telling us. Yes, paragraph 5. Which paragraph 5? Law and claims officer. Yes. Well, denying the statements, there is no such public which leads to the Mahamanasa temple. The land belongs to STC and the temple was over the land. The plot was used by public for general use and visit only and not to be used for any other purpose. Okay. So people walk.
Lordship.
to
Only
that
for the temple only, Lordship.
Okay, how much is the distance from there to this place? To his land?
Your lordship, distance is 72 feet, your lordship. In after conversion from 22 meters.
From?
It is
No, 72 feet from where? From Rupnagar
Rupnagar Road
to your place?
to the Mahamanasa temple, your lordship.
No, to your thing.
Yeah.
To your place.
Correct.
How much? 72 feet.
70.
11. No. These are all meters.
Meters, your lordship.
This is 20 plus 22.
22 meters,
is
your lordship, it is equivalent to
44.
70.
I know it has to be more than that. It has to be more than that. If we say so, because this is 22, then 11, 20, 33 plus almost 10, 43 into 3. It will be more than 120.
I get
120,
your
like
lordship.
130 feet.
And rate is 8.2.
130 feet.
That is the part, your lordship.
Hmm.
And on that, your lordship, that is the part.
Because what you are saying, you want this government land without an allotment.
This is not government land, your lordship.
It
This
is whose land?
STC's land.
No,
STC, after all, it's a government
Government.
company.
it's a government, Lordship.
Not government land, your lordship. Why I'm saying, your lordship, the government has no,
You want for specific performance, why are you not going to the civil court?
what sort of specific performance, your lordship.
No, if you want
No,
that
you are
there is an agreement entered into, they have not, they are cancelling it, challenge the cancellation in the civil court.
Lordship, that will take time, your, that is not.
It
the-
is going to take time if you want this court to
It is-
exercise
it
this
is not
remedy out
adequate.
there.
It is not adequate relief.
Hmm?
Some of the contract is concerned, your lordship. Under Article 226, we can challenge it here because alternative remedy, and this is not alternative remedy because in fighting the civil suit for years together, that is not the efficacious remedy, your lordship. Efficacious remedy is instant remedy, your lordship, and legal remedy. Now, we are in this case, your lordship, if today your lordship decide in my favor, then it is a final decision, your lordship. For the same relief, your lordship, if I go to civil court, your lordship, first appeal, second appeal, and.
But can this court direct them for enforcing a contract?
No, only, I am not on that, your lordship.
You are only challenging the cancellation.
Cancellation, termination, your lordship, that is without notice, without show cause notice, your lordship, without any opportunity of being heard, your lordship, nothing. And that the person who has actually cancelled it, he is not a party to the agreement. He is the state, your lordship, that is the secretary transport department. He is not a party. to
Where is
the
the impugn order?
impute order at face, your lordship.
86.
Um,
Some of the decisions taken in the 178 meeting are
It's a 10-year
inconsistent with the laid down
Section
procedure and
at
rules.
base.
Reports on the matter was called from the managing director and after report of the manager and the issued.
86.
data is hereby cancelled with immediate effect.
So he has no jurisdiction.
Why?
Lordship.
He is no way connected with the
Lordship.
STC matter, your lordship. It is the board of directors. They have people
Lordship,
entered into the
the-
agreement.
Process of allotting the land to the petitioner was took in the board of directors meeting of 178. entire 178 board of directors meeting was being set aside, has been cancelled by 179. The minutes are already before your lordship of the, as well as the report which the managing director STC has submitted to the government. Based on his report, entire board of directors, 178 board of directors meeting was cancelled. Minutes are before your lordship.
Yeah.
And regarding the cancellation of the land by the government lordship,
Deliver upon the issue on the proposal for allotment of land for giving any access on the one and to. So it has not yet been cancelled.
lordship.
It has not been cancelled.
178 board of directors meeting has already been cancelled.
Where? To me,
Lordship.
you are referring to clause 6A.
No, lordship, this minutes of 179 reflect.
I've seen it.
Lordship,
Clause 6A. Look how the
lordship, with the
clause 6A. Isn't it? You have disapproved and said that you are not doing anything in view of the pendency of the petition.
lordship, this, yeah, this one.
Yeah.
Since it's a sub judice matter, lordship,
Yes.
but the entire board of directors, that's.
So you have not cancelled it.
Yes,
Cancelled your lord. If they have cancelled your lordship.
No. Board of directors have not cancelled it.
Yes, your lordship. It has been imposed by the secretary, your lord.
Understood. It
Yes.
is the secretary who have done it. The board of directors have
No,
not.
no,
Is what.
They have followed it.
and moreover, lordship, the land which the petitioner is claiming to be the ASTC's land, it was being allotted to the ASTC, but it has not been mutated till date, lordship. It belonged to the government only, it's reflected from the circle officer report also, as well as the Sitako. I have.
Such as. We don't expect such arguments. You have been allotted, you got the allotment. Mutation is for the revenue.
Lordship.
Then yes, what is the authority, madam? What is the authority of this official, the secretary of the transport department over the ASTC?
Lordship, before that, Lordship, may kindly have a look 179 Board of Directors meeting, my lord, the minutes. The review on the agenda of the 178 Board of Directors meeting held on 21/5/2021, my lord.
Page.
First page, Lordship,
Yeah.
the minutes that is provided by the ASTC, my lord.
Hmm.
179. What happened, Lordship? The decision which were taken on a 178 board meeting by the Board of Directors, my lord, all the decisions were cancelled, my lord. And the
Understood, but what authority does the Secretary of Transport has over
my lord,
ASTC?
the secretary Jadab Soikia was one of the member in the Board of Directors meeting, my lord. And the decision which were taken by the board, some of the decisions, my lord, which were taken in the 178 board meeting has been wrongly placed by the then MD, my lord. Because the minutes were never vetted among the members which were present. And some of the members has objected that some of the decisions taken by then MD lordship. So that's why he did not circulated the board minutes among all the member present. He himself done all
Understood.
this, my lord.
Whatever may be, let
My
the
lord.
board do it, not
Lordship,
on that.
my lord.
But what is the authority of the Secretary of the Transport over the ASTC?
Lordship, then Lordship, may kindly have a look our affidavit, my lord. Why
Yeah.
we have cancelling this
Respond number 3,
5, my lord.
respond number 5, yes.
Lordship, may kindly have a look from paragraph 4, my lord.
Hmm.
Page 2 of my affidavit, my lord, got it? Paragraph 4, my lord. May I read, my lord?
No, I've looked into it, but now tell me, what is your authority? I'm asking you a specific
Financially,
question,
the
madam.
ASTC is fully dependent on the government, my lord.
For what?
For financial,
So you can do whatever you mean.
no lordship,
Then-
because the report that has been submitted by the MD, my lord,
No, was the report
my lord.
or was the agreement subject to the concurrence of the government?
Yes, lordship, because the minute was not valid, my
No,
lord.
was it required to be concurrence? See your ASTC rules. Is it required that it has to be sent to the government for concurrence? If it is not, then what authority does the secretary have over the ASTC?
Because some of the items, lordship.
Isn't that the ASTC a corporation under the statute?
It's a corporation, but.
So it's a statutory authority.
Yes, my lord.
Then whatever may be, the government may help them do whatever may be. But can they do so?
But lordship, the MD ASTC has told me, my lord, because some of the decisions which were cancelled by the secretary and he was on the member, but after that the board has again placed some of the decisions which were cancelled. And department has also agreed to that. And then this matter, they can also place before the subsequent.
Now,
Board of the
what is the business of the secretary over the ASTC? Show me that. Can
Lordship,
can
the
the
person
secretary overall take a decision? Yes, the board can very well review, do whatever may be. There's no quarrel with that. But how does the secretary come in? Unless you show that, yes, the board's thing has to be approved by the government. Anything to that effect. Can you show that?
Yes, but there is no regulation, rules and regulation regarding
And-
that, lordship. But lordship, the secretary Zadav Sekia, who was also present.
How
in the
the,
meeting.
where is the formation of the board of directors? How is the board of directors of the ACC
He's
commission?
a member from the different department, my lord.
Understood, but how is the formation? Is it on the basis of a statutory provision?
Lordship, I don't. think so. ASTC, my friend will advise you.
Mr. Das, you don't know, how is your client formed? And madam, how can you say that your authority could have exercised the power over them? Yes, they might be wrong. They might be wrong. In fact, the revenue may say tomorrow that, look here, we gave you this land. Who are you to part with and give it to somebody? Revenue may say so. But why is the transport department secretary can say anything to the effect?
Lordship, not only that decisions, my lord, but all other decisions which were taken in the 178th board meeting has been cancelled due to some other reason. The report is.
Understood. Let them cancel it.
They may,
No, let them cancel it. Who are you?
but they have adopted, I think.
They can't do it. They let them do whatever they
Yes,
feel like.
lordship, the director.
But who are you? You are nobody. You look into it. I'll take it on Thursday. Look into it, whether you have the authority. Because if I say you don't have, later on you come up with some authority out there, then the authority, this secretary will say that Miss MD Bora didn't actually point out properly.
Lordship.
In support of that, I have already cited two decisions of our High Court that the government has no overriding power upon the decision of the Board of Directors. Two decisions already we are in.
Fact is the different,
Yes.
totally different. On
Fact-
last occasion,
If
hearing
of
was
that two
conducted
decisions,
for
your
2-3
lordship,
hours, my lord.
Division bench
No. This court doesn't require this. This matter is a short
Yes,
matter.
my lord,
What is there? You only have to show me the authority.
my lord.
If you have the authority, good.
Government.
You don't have the authority.
There is no overriding power over the decisions of the board.
You are showing which judgments?
Lordship,
That
Yes.
Bongaigaon municipality.
Lordship,
You are referring to Bongaigaon municipality.
correct, Lordship. Boygaon and the South Chennai, your lordship.
Not entitled to intrude into the properties vested in the
2005.
corporation at its will and pleasure. Then
Lordship,
the land in question had been acquired for the benefit of the then existing transport which stood vested in the corporation by operation of law under which the corporation is entitled to hold the same and dispose of it in its own discretion. The state government is not entitled to intrude into the property. These are division bench judgments.
But the fact is different, lordship. So for
Understood.
I-
Whatever may be, you show me what is the authority of the secretary.
Lordship, Thursday, Lordship.
Matter has been heard at length. This is the matter again on 3rd of August 2023 for further consideration.
My lord, deeply obliged, my lord.
We'll finish. We'll get the order. If she can't show. Requiring elaborate hearing.
Obliged. Lord.
Oh, here's some regulations. Both sense.
There is no regulation that admitted your lordship, whatever the rules framed your lordship under the Road Transport Act. That is there, we have already filed this, your lordship, that is there on the code.
And so this is an act to provide for incorporation of regulation of the corporation. So this is Road Transport Corporation is a statutory body.
Not under the rules.
Chairman and meeting of the corporation of a corporation shall at such time and place and shall subject to the provisions of subsection observe such rules and procedure provided by so and so part the appointment is of executive officers, general duty of the corporation, appointment. Here it will also be there. This provision will be there here.
I think Lordship 34.
Fund of the every corporation shall have its fund and all receipt of the corporation shall be carried here to and so you can find it. You show me that, huh?
My lord,
What authority you have. If you
Sir.
don't have the authority, matter is.
my lord. Obliged.
You want it tomorrow?
That's it,
You want it tomorrow?
after tomorrow.
Tomorrow?
Tomorrow your lordship, a little bit difficult.
Okay.
Let it be on hard your lordship.
Okay.
Timing at one.
Friday, Lordship, can you take a Friday? I will get the instruction by today itself.
And it can anyways, on Thursday you get your, only find out if there is.
My lord.
mistake.
Lord,
Yes, Mr. Mazumdar,
obliged.
what did you say about your limitation?
But Section 12 will not save a suit, madam. Other applications save.
Understood. That is why I'm thinking, can we bring within the ambit of arbitration?
Same question may come, madam. Limitation question will
Hmm?
come. Even in arbitration, the question of limitation may arise.
Understood, but taking into account.
Right.
See, limitation for arbitration is different. Have you raised the dispute?
Till now. Till now,
No, you have raised some
the
dispute,
dispute we have raised, but not, we have not invoked the provisions of arbitration.
not necessary. But if you see section 23 of the Arbitration Act, 23 or 21, have a look. Arbitration Act. For suit, it will be difficult.
Difficult.
But if we go for arbitration, can we say that 21 can be 21 or 23, whatever may be? Good for arbitration. এখন কোপায় না? Repeat. ফেনখন কমাই দিয়ক মোৰ চুৰ বিষালে কালিৰ পৰা কৰিব নোৱাৰিম Yes, 21. Unless otherwise agreed by the parties, the arbitral proceedings in respect of a particular dispute commence on the date on which a request for that dispute to be referred to arbitration is received by the respondent. That we have not done. Have you done that?
No.
Now, taking into account,
Minor.
now taking into account that they have stated that the dispute is arbitrary. Can I refer the 226?
If they say now they cannot object. If they have said so, they
They
can.
can't object.
Yes.
So if that be so, can I refer? Once I refer it, then it would be a continuation of that proceeding.
Yeah.
That is the only way out, I see. There are few judgments. Supreme Court
This part, I have not looked into the lordship. Sometime I'll just see.
will have it on next Thursday.
Minor.
Just, there are few judgments
Well,
I've
I
seen,
look-
226, the court can.
Yeah.
Taking into account this, and the parties having agreed to, you now agree,
Now I'll be.
and he has
has already
already
agreed.
said so. We can refer it,
Well,
then in that regard, that is the best option which can be done. And I think there are 2-3 judgments,
I'll look.
just look into it.
Thursday.
So these are top of the list matter. This is the, was partnered.
Let it be kept partnered. Lordship may keep it partnered now.
No, I don't require partner. This matter will come, don't worry.
Earlier,
And
Matter was-
and top of the list.
earlier the matter was heard by another bench 2-3 days, then it was not kept partnered. So lordship may keep it partnered now. Otherwise, again, the bench changes.
I don't have partners. Not a single partner, not a single seat.
CFP. No, if your lordship makes it partner and list it in the.
Not necessary. It will come before me because you see, this I think has been assigned to me only.
Possible.
I think so. Let's see. असं नहीं को बच्चों तो असल में स्टेक हो तो लास्ट को
Last time it was listed before a different bench and again it was written as top of the list. Here also.
Why it was before you? In your matter mutter right there. Top of the list. I think you're top of the list to the current. It is not 12 years. Top of the list here. Administrative note.
The India Pacific part.
ये होगा नहीं क्यों तो rule you speak for hearing क्यों का नहीं okay लेखो The learned counsel for the petitioner as well as the respondents have been heard at length. The issue during the course of the hearing, an issue arose as to whether this court, in exercise of the powers under Article 2 to 6 of the Constitution, refer the parties to arbitration by appointing an arbitrator as per the mutual understanding of the parties, as per the mutually agreed to a mutually agreed arbitration. The legal counsel for the party submits, they would look into the state respect to the matter. And also would take into account, would also try to reach a consensus as to, for appointment of a mutual arbitrator. Would list the matter again on 3rd of August 2023 for further consideration.
Obliged. If
Ano lang ito,
It will come this week, it will come.
no, it will come before me.
Item number 8 for hearing.
Hearing, hearing people.
May I please object? Madam, sir, I'm
Yes,
saying- Madam,
what is this matter about?
My lord, this is regarding payment of compensation for allotment of land to APDCL, the patta land of the petitioner.
Madam, sir,
62 petitioners are there.
Huh?
62 numbers of petitioners is there.
62. And you have paid 60 rupees?
No, ma-
Yes. 60.
petition is different. There is a bunch of document, my lord, for convenience. I have prepared some bunch of document and.
No, you have so many petitioners.
Yes,
You have
sir.
only paid 60 rupees.
Yes. Yes.
Court fee. Right? Your land has been taken.
Yes,
No,
compensation and pay.
not paid. Yes, Mr. Yeah, who is the petitioner? You.
Madam, sir, we are newly engaged.
Huh?
We are newly engaged as
You are newly engaged means there is a change in the APDCL council.
APC,
Who is it now?
Dipankona. Dipankona. is newly
Where is he?
engaged.
I saw him now. Where is he?
I am praying for 1 week time now
For what?
for hearing.
And Karbi Anglong? Why? What has happened? Why you have taken the land and not paid?
No.
APDCL couldn't have taken the land from you. You must have given it.
Land was allotted, my lord.
To?
To the APDCL, my lord, for construction of hydroelectric project.
Hmm.
But at the time of construction, Assistant Revenue Officer submitted a report that they have constructed the road and other things in the patta land. So controversy on that one.
Then
And regarding my allotment, we have allotted that land, the APDCL only pay the allotment fees. And at the time of allotment order, it specifically provides that they have to pay compensation to the affected family. That has not been done. That is the case one.
so you support the case of the petition
Petition.
and you have not
But-
paid.
We are newly engaged, my lord, so we need some time.
But
Regarding
you have not acquired.
land is not acquired by.
Then how can they make it?
But the land
How can you
acquisition were 233 because lands were allotted by the council.
But how can you allot their land?
Now, we cannot allot, my lord, but at the time of construction, my lord, this is a hilly area, there is no demarcation, that is not cadastral land. So at the time of construction, they constructed certain roads and other buildings in the patta land. That is the case, my lord. And the other point is also there.
Without acquisition.
There is no acquisition, without acquisition, my lord. But as there was no demarcation, the case of the petitioner is that they constructed the road and the some buildings in the patta land, my lord. So without paying compensation. Our case is that we have allotted the land. In the allotment order, it has been provided that they have to pay the compensation.
But did you allot
200
council's land or their land?
No, we allotted the, my lord, government land,
You allotted government land,
my lord.
but APDCL used their land.
They constructed certain roads and other things, my lord, other buildings in their patta land, my lord. And the other points is also their pattas were issued subsequent to the allotment order. That is the point of the APDCL. Whether we can issue patta after allotment of the land, my lord. That is also another point. That is also required to be considered.
Once you have allotted, then you can't issue patta.
That is the point, my lord.
Customary law.
My,
This is the customary law
Customary law for what?
for Karbi Anglong.
for Karbi
Karbi
tribes,
Anglong,
my lord,
because-
Karbi tribes, as per the, my lord, customs, my lord, the Sarti, that is the, Naugura is the head of the, my lord, land, my lord. When the people leave the places earlier, my lord, then the land belongs to the, my lord, Sarti. And as per the customary law, as the Sarthi is the owner of the land, whenever the potta is required, earlier the pottas were issued like that way. And it is a non-cadastral land, abandoned land was there. So pottas were issued, that is admitted fact, my lord, after allotment of order. And on the last order, lordships, the order was passed to take the instruction, what is the amount we have calculated as per 2013 Act and who are the beneficiaries. That instruction I don't have also. And after enactment of my lord, our act, my lord, own act, Karbi Anglong Land Revenue Act, whether we can issue potta, my lord, that is the law for. Whether customary law will prevail or our act will prevail.
You have made the,
We have made the act in 1951, my lord, 1953, my lord, Karbi Anglong Land Revenue Act, my lord. And by enacting that act, we have adopted the Assam Land and Revenue Regulation 1886. So Assam Land and Revenue Regulation 1886 is applicable. But as per the customs, my lord, Sarthi is the, my lord, owner of the land. So the council, after allotment of the land also, pattas were issued. The deputy commissioner.
but
also
is the
taken
land belongs to the Karbi Anglong?
Karbi Anglong.
How do you say so? How it is belongs to the Karbi Anglong Autonomous Council,
Council, my lord.
then where is the question of issuance of patta?
My lord, that is the point, my lord. That is the point raised by the, my lord, whether customary law will prevail or the, my lord, enactment of the act, my lord. As for the 6th schedule, my lord, we have the power to enact the act. We have enacted the law, my lord.
And APDCL have
And
constructed,
APGC, my lord, they have, my lord, they have sent a proposal for a joint verification of the land, my lord, which they have enclosed, my lord. As the case is pending, Assistant Revenue Officer or the council has not taken any decision as the case is pending before this court. So there is no joint verification. APGC wrote to us, my lord, for a joint.
but
verification.
whether there is a, only one thing, whether APDCL have encroached upon, forget about the patta issuance or not,
But-
have encroached upon only the allotment land, allotted land or
Or the
beyond
patta
that.
land, patta land also.
So then it is a different aspect.
There are two aspects are there, my lord, here.
So one is a patta land which irrespective of the allotment,
Allotment, my lord.
and one is
Allotment of
allotted
the
land which were also patta issued.
Issued patta issued subsequent, my lord. That is the two issues.
So there are
And
two
the-
things.
Two things, my lord, and the joint inspection, the chief general manager wrote to us, my lord, APGCL. Therefore, a joint verification to verify it, my lord, to the, who is the actual possessor of the land and the recurring.
How much time will it take?
My lord, as the case is pending, joint
We'll take
verification is
care
not
of that.
carried out, my lord.
How much time will it take?
But it is jointly, it is required to be carried out, my lord. And
Ah.
if the petitioner wants also, they, my lord, they can also join, it is required to be jointly verified.
When? How much time will it take?
But 6 weeks,
We have it in the month of September.
my lord. And if your lordships give us the liberty for
I'm
joint
giving you the
verification,
liberty.
both us, my lord, then it will be joint.
Let there be a joint verification carrying out and they let them
In the
submit
presence
a
of
report.
petitioner also, my lord.
It's not okay. Allowed to participate.
Yes,
Yes, my lord.
we will have it in the month of 19th of September.
My lord.
I think 6 weeks will be done.
Let me get it 2 months, my lord, then I'll refer it later, my lord.
Say thereafter the problem arises, we can have it then on 5th of October.
My lord.
The issue involved in the instant petition is that the petitioners are claiming compensation from the respondent APDCL,
APGCL.
APGCL.
as well as from the Karbi Anglong Autonomous Council,
We are claiming compensation from APGCL,
APGCL, AP,
Power Generation
Corporate.
Corp.
Power Generation Corporation. APGCL এইটো ফুল লিখি দিব দেই Assam Power Generation of the case of the petitioner's hearing is that the petitioner are aggrieved by the non-payment of compensation on account of non-payment of compensation by the respondent Assam Power Grid Generation Company Limited in respect to their land. Mr. J. City, the learned counsel, standing counsel, appearing on behalf of the Karbi Anglong Autonomous Council, submits that there are two aspects of the matter. First aspect pertains to occupation of the APGCL authorities upon the land belonging to the petitioners. And the second aspect pertains to land which was allotted to APGCL, wherein subsequent pattas have been issued in favor of the petitioners.
Subsequent issuance of patta
Subsequent pattas have been issued to
to the petitioner.
petitioners. He submitted that on account of the pendency of the instant writ petition, he further submitted that the Karbi Anglong Autonomous Council had taken up a joint verification exercise in respect thereto, but could not proceed thereto in view of the pendency of the
APCL pilot wants a joint verification.
He further submitted that the Karbi Anglong Autonomous Council had, at the request of the APGCL, initiated a joint verification exercise. But on account of the pendency of the instant writ petition, the sake could not be proceeded with. This court is of the opinion that if a joint verification report is obtained, is placed before this court, it shall be is placed before this court. The same would be in the interest of justice for an effective adjudication of the dispute. Accordingly, this court therefore directs the registry to list the instant writ petition again on 5th of October 2023. In the meantime, the Karbi Anglong Autonomous Council shall carry out the joint verification of the lands in question It is further observed and directed that the Karbi Anglong Autonomous Council shall also give the APGCL as well as the petitioner permit the APGCL authorities of the APGCL as well as the petitioners
Joint verification with
participate.
EPGCL matter.
to participate in the said joint verification process.
They need to notice petition, otherwise petitioner will not know when this verification is going on.
That is you go and
I will inform her, my
Inform-
lord. It will
they will
be
inform, my
difficult. I'll inform the date of
the learned counsel appearing on behalf, Mr. J. Sutia, the learned counsel appearing on behalf of the Karbi Anglong Autonomous Council submits that he shall duly inform Miss P. Burman appearing on behalf of the writ petitioners the date and time for carrying out the joint verification and full stop. Next. It further appears on record that there are 62 petitioners and only court fee of one petitioner have been paid. The learned counsel appearing on behalf of the petitioner submits that the deficit court fee shall be paid
My lord,
on or before the
common,
next day.
my lord, common interest, so we need to pay one. All are having common interest in it.
Then test. Are you agreeable to the compensation of only one person? Then everybody has different. In fact, the petition should be on dismissed on that. How can they be common intention? Everybody has a different. On or before the next.
One separate. Oh, thank you. One second.
Yes, Mr. Dotto, you are waiting for something. Give your name.